Do we have everyone online now?
This is the moderator, yes.
Great. Sorry, I was just waiting for it to tick over to 10 a.m. here. This is Dr. Dara Thompson. I am the chair of the Naturopathic Medical Board, and this is our meeting for June 29th, 2023. And we will be beginning that meeting with a roll call. Rebecca.
Absolutely. Thank you so much. Dr. Dara Thompson.
Present.
Dr. Greta D'Amico.
Present.
Dr. Vera Singleton.
Present.
And Dr. Deparshi Mukherjee will be absent with cause. Dr. Bruce Davidson.
Present.
Dr. Mina Yoon.
Present.
And Mr. Andy Yam.
Present.
Great. Thank you so much. We have a quorum.
Fantastic. At this time, having established a quorum and called the meeting to order, we are going to ask for public comment on items not on the agenda. Do we have any members of the public present?
This is the moderator. We only have the DCA TV specialist in attendance.
Thank you.
Would you like me to proceed with the instructions on how to?
Yeah, and then we'll wait a minute, and if no one has any comments, we'll move on to the next item.
Okay. The instructions are
Thompson?
on this.
Sorry to interrupt. This is Michael Knotes, legal counsel. Because we don't have public in the audience as of yet, what we can do is for this item and whenever we go to public comment, we can just check in with the moderator. And if there's no public present, we can just keep moving.
That's lovely and efficient. I like that. Okay. So then, seeing no members of the public present, we can move on. Unfortunately, agenda item number 3, which was the approval of the meeting minutes from November 10th, 2022. There was a glitch with that where the final meeting minutes were not sent out in a timeline that's going to allow us to review those. And so we are going to have to move that to our next meeting agenda for approval. So we are going to move on to agenda item number 4 at this time, which it says board chair welcome, discussion, and possible action. Rebecca, can you elaborate on exactly what's supposed to happen with this item?
I was just giving you an opportunity to bring anything that you had, any updates from, prior discussions that you updated us with, if you wanted to.
Well, I don't think that there's any specific items that are not on the agenda that we need to discuss right now. As you know, we were both on the FDA panel this morning, and just informing everyone that we're continuing to participate in these FDA discussions on IV nutrient therapy and regulations around in-office compounding, et cetera. Just wanting to make sure that we are clear on all the current requirements, but also giving our opinion on what we've seen in our state, and just moving forward that the next meeting is going to be on July 26th, and we'll certainly update people as to what is on that meeting. This was more of just a preparation call. Okay. We're just blazing through this agenda. The next item, the next item here is the update, discussion, and possible action on proposed regulations. The first one being the IV therapy and advanced injection therapy language, but we have a significant glitch with that based on recent report we got from legal. So I'm going to ask our legal to give us a little bit more information on that and what areas we're going to need to change in this language in order to move forward. And I definitely have some questions around that as well.
So, Chair Thompson, may I proceed, or Christy Shields who's talking at the moment?
Hi. You mean proceed
Hi.
on to agenda item number 5?
Great, thank you. So by way of introduction, my name is Christy Shields. I'm an attorney in the Department of Consumer Affairs, Legal Affairs Division. I joined the division in 2000, and I've served in various capacities as board counsel, litigation counsel, and employment law counsel for various boards and bureaus in the department. I'm currently assigned to the regulations unit. And since I started in the unit about 3 years ago, I've been doing what they call second level review of all regulation proposals. So the regulations councils will submit the board's proposals to me, and I will review them to see if there's any issues I think need to be brought back to the board. And so after your last meeting in November, I received a copy of the text, which is item 5A3 online and in your packet, that the current advisory committee has put forward as an option for initiating a rulemaking. And after reviewing that, I advised the executive officer that I thought there were authority issues and other issues with the proposal. And if you've seen the memo, which I referred to you in attachment A5A, that memo outlines the concerns I have with the proposal and a recommendation I'm providing to refocus the discussion around IV administration, because the primary proposal that's currently before the board really seems to focus on continuing education and further education. There is some touching on completion requirements for the course that the naturopathic doctors have to complete, but it's really focused on continuing education and additional education. And if you look at attachment A5A1, which is the bill text, from the law that enacted this authority for naturopathic doctors to do IV administration, the requirements in 3640.8 really only require that a naturopathic doctor have a current license and complete a qualifying course in IV therapy from a course provider approved by this board. And if you look at the subdivision B of 3640.8, it's pretty specific about what those course requirements have to look like. 25 classroom hours in IV administration, 14 classroom hours in identified as practicum. There's course content covered. There's the completion rate. All of that is already dealt with in the statute. The section of the law that the board, I believe, should be focusing on implementing is subdivision D of 3640.8. So if you look at that bill language I was discussing with you, the law hasn't changed, by the way, it's the same. So we're looking at subdivision D. It says pursuant to subdivision E of section 3640, the committee, which is the board, may establish regulations regarding IV administration that are consistent with the education and training of a naturopathic doctor. So I believe the focus of the regulatory proposal should be on developing IV minimum standards for IV administration, because the education piece, I believe, is already covered in the statute. So I don't think that's a small task. I do think that's an incredible delegation of authority by the legislature. It's not insignificant, but I do think the resources should be focused on that sort of task and removing any requirements in the proposal about additional education, because the statute says if they've done the course and they have a current license, they qualify. So I think that door has been closed, so to speak. If the board's interested in pursuing additional requirements, I would refer you to your board counsel and a future agenda item to discuss that option for further continuing education, if that's a policy you want to pursue. But right now, I think that the development should be on IV administration. And if you look at the legislative history of SB 1446, which I believe we also provided you an attachment of, and I've quoted on the first page of the memo at the bottom and continuing on page 2 of the memo, some of the discussion of IV administration covered things like site selection, infection control, and avoiding emergency situations, like perhaps establishing emergency protocols that need to be adhered to if there is an adverse event. These are areas that it looks like the legislature was interested in when they were enacting this legislation. So I think that would be something that the advisory group would probably want to take a look at and see what the current, and this is what the kicker here is, current education and training of a naturopathic doctor requires, so that the standards the board's proposing are consistent. And they will have to be maintained going forward. So my recommendation regarding this proposal, I've indicated on, you look at page 4, I'm recommending amending the current proposal to further specify administrative course approval and minimum standards for IV administration only, and to remove from the current proposal references to additional training, recertification, or course content requirements as criteria for a naturopathic doctor to administer IV therapy at this time. And I'm going to turn it back over to the chair to see if there's any questions the members may have on the advice, and it is advice.
Thank you so much for your time and your detailed review of this information. I have a couple of follow-up questions, and I'm sure several of our members do as well. So I'll just show my video so we're talking to each other. Am I to understand, based on this, that we cannot add any additional requirements for continuing education that are outside of our current law for our licensees? Because that sounds like what you're saying.
Yes, that's my interpretation based upon the review of your Practice Act. If you look at, and I discussed that a little more detail in the memo, if you look at your continuing education statute, it doesn't say anything about giving the board authority to require what they call dedicated continuing education. So when you have authority to do that, the statute usually says something like 60 hours of continuing education in any of these areas and any other areas prescribed by the board. And then, oh, we have a ticket, so to speak, of authority. We have authority to go forward and promulgate regulations that specify you have to have, so many hours in ethics, so many hours in substance abuse, prescribing, whatever the areas would be. And so those are the statutes I've seen where we've been able to adopt regulations to further prescribe and require additional education. And so, I scoured your act, and I don't see anything that even resembles that. And if you look at and I quoted the statute in here, your continuing education requirements are on page 3 of the memo. I quoted it there. You can read it yourself. BPC section 3635 has to be at least 20 hours in pharmacotherapeutics, no more than 15 hours in medical journals, 20 hours in any single topic, no more than 15 hours for the specialty certificate in naturopathic childbirth attendance, Course content has to pertain to the practice, osteopathic or allopathic medicine, naturopathic, osteopathic, or allopathic, and you can obtain the education from various providers. So there's really no, I looked for a way to try to argue that we could do that, and I couldn't find it in there. I think you'd be on more solid ground if it's important to this board to seek a legislative amendment to 3635 that would give you authority to prescribe other content areas. And maybe there's others besides IV administration that you're interested in. I don't know. But that's a policy discussion for another day. But I think our reg authority is really limited to IV administration standards. So right now.
Yeah, thank you so much. I think that, you know, for me, the concern, since our role as one of public safety, is that medicine is ever evolving, and it seems like in the longer term, we do need to have the ability to require our licensees to get additional training if, you know, there are changes in what they can do or the landscape of medicine, et cetera. So you've really brought something super important to our awareness, and it may be something that we don't address until our next sunset bill or something like that, where that could be something where we might address it in that situation. But you're saying from a regulation standpoint, we can't do that. We would actually have to amend the act.
Correct. That's my opinion. Yeah. I mean, I spent many hours looking at different ways, discussed it with management. We're just not seeing that authority to make the interpretive leap of saying, oh, the legislature impliedly conferred upon us this authority. Well, what's our argument? It just seems very straightforward, that statute. And if you look at the specific statute that implements 3640.8, it says they only have to meet two requirements to administer. That's it, period, boom. Current license and that 25-hour course. And it's very specific, that course content, what they have to take, the pass rate for the course. I mean, what the hourly, I mean, they didn't leave a lot of room for you to go any farther on the education piece, is my point. And so I think the focus should instead be on subdivision D of that section, which says you have the authority to develop IV administration standards. And again, it's no small delegation. Not very many boards get the ability to set the professional practice standards for the profession in regulation. And it is, because it is a public protection issue, there's a lot of ways to approach it. I'm not a naturopathic doctor, so I'd have to refer to the experts on this board and in the committee, advisory committee, as to what that would need to contain. But it seems like the legislature was kind of giving us some signals in the ledge history by touching on things like site selection, infection control, and discussions regarding, what things can go wrong if there's an infection appearing at the IV site. So things like that discussion I've quoted from at the top of page 2 of the memo would be, I think, areas we could explore. There may be others you want them to explore, or they are suggesting you explore, that are needed to ensure safe practice. And we really need to engage our stakeholders, because as you saw the bill committee analysis, there was opposition to this bill. So you want to make sure you've covered your bases there and you've really been thorough in your review, and you've tied it to, as the statute says, the education and training of a naturopathic doctor, because the legislature felt that this profession was capable of doing this practice independently. And so I think that, we go with that legislative task, and anything else you think needs to be done for the protection of the public, I would put on a separate agenda item going forward.
So thank you so much. I have one more clarification question, and then we do have some questions from other members of the board. There is a significant section on continuing education in the language as it is currently written, but there's also quite a bit of information on standards in the office, staffing, emergency material, etc. you did not see any problem with those sections, did you?
Well, there are some things I want to clarify. I have some clarification questions, but I think that there are parts that we can certainly work with. There is some infection control touched on in there. There are issues about emergency and that, but I think not all of it has been flushed out. I have been at the department for a long time. I've done infection control regulations for many boards. I've worked on compounding regulations for the pharmacy board. I know how involved they are. And I'm thinking there's probably more to it than and this is a good start in that regard, but I think that we probably need to flesh that out a bit more. In my discussions with your executive officer, she seemed to think there were, other states had done more in-depth development of minimum standards. We might want to look at those too. But I think what I'm trying to get at is it's no small task to set minimum standards for administration, and it involves a lot of different things, as you know, as a practitioner. There's a lot you have to consider. And so what we're looking for are those minimum standards for safe practice. And so what I'm not seeing is all of the things that were covered in at least from my experience in working with infection control regulations and the legislative kind of discussion regarding things like site selection and risk, like what can we do to prevent risk of certain things happening if it's not properly administered. What are those things? What are those triggers? What are those minimum equipment requirements, like you were saying, staffing, whatever we need to make sure that the IV administration is done for the protection of the public. And so I think there's a lot to look at, and I think we need to do more research and development before we would move it forward, because there was opposition. We don't want to have someone come in and adversely comment on your rulemaking, holding it up. We want to make sure we've shown the control agencies that review regulations, because it's not just our office, it's the director of the department that reviews regulations and approves them. It then goes to the Business Consumer Services and Housing Agency. Attorneys there also review it and can disapprove regulations. Then it goes to the Office of Administrative Law, where at least 3 more attorneys look at it. There's associations, not just the Naturopathic Doctors Associations, but other medical associations that may comment. So we want to make sure that we've kind of dotted our I's and crossed our T's on everything. And we've done a comprehensive look at what needs to be done to avoid any of that kind of potential adverse comment, because that would prevent you from adopting these regulations down the road. And so my experience has been, if we can get a good, solid product out and we circulate it to all stakeholders and we get that input and we've shown we've done our due diligence, you will have a pretty smooth regulatory experience. But if we don't, then there's a good chance it's going to stall and not be adopted anytime soon. So.
And what is your availability? Because you seem to have a lot of expertise in this area while we would make those changes. Is that something we can continue to talk to you about? Or is this like our one chance to ask you questions? I just want to.
No, my management has seen that this is an important regulation for this board. And so one of my jobs is also to act as coverage counsel when boards lose their counsel. So I've been asked to kind of spearhead this one and keep involved in this regulation development, even if you do get another regulations counsel assigned to your board. And, of course, I'll work, hand in hand with your board counsel too, to make sure any issues they have are addressed. But yeah, so my management's asked me to continue working on the IV therapy one, just because it is technical and I do have experience in these areas. And so it's just a matter of making sure that we can get the advisory committee together on a regular basis, and we can get everybody to make themselves available. to
We do have
continue
a
working on this.
committee that works on this that's composed of 3 people, so that's a little easier to convene a meeting on.
Okay, I hope so.
I'm
That would be
gonna
great.
I'm gonna ask Dr. D'Amico, who's had her hand up for a very long time, to step in with her questions and concerns.
Okay.
Hello. So in my work with the board, when I think about all this type of stuff, I'm a big picture person. So I think about what is the problem that we're trying to solve with any action that we take. And we need to be very clear about the difference between legislation, standards, and guidelines. Because we certainly can be in the position to encourage people to do things a certain way. For example, renew your license online rather than sending it in because you'll have a better experience. But we can also, we already have educational requirements that are more specific, more rigorous, and more numerous in hours than any medical professional in the state. So I don't want us to just keep going forward with the assumption that we have to keep making more and more rules and more legislation for everything, because we don't necessarily. When medicine changes, that is the reason that we have a requirement for continuing medical education. And as a rule, it is left to the professional who there's a certain level of trust in because of the education that they were required to receive to decide where they need more education. Some states require that you write out an educational assessment and plan about how you're going to learn, but that is sort of assumed in the regulations that we have or in the statutes that we have for education. So I just want to encourage us to, yes, we should have standards and guidelines, and remember that word minimum. Just like our board examinations are to qualify a person for a minimum level of competency. It doesn't mean that they really know what they're doing necessarily, but that we trust them enough not to harm anyone and to continue to learn what they need for the area that they choose to focus in their practice. So I just say all of this because I think a lot of this got initiated, and correct me if I'm wrong, because of one incident that happened that was in San Diego and the comment of a DA in San Diego that we should have more regulations. And based on one person's comment, we went on this big road of 2 years at least, or 3 or 4 years of trying to do all these regulations, which now don't even apply in terms of education. And we should never react just because one person said something. We should always look at the bigger picture. And I agree that it is important to have an understanding, just like a parent says, my expectation is that you're going to tell me the truth, that you're going to own up to the things if you did something wrong, that we're going to have a conversation. You can have those expectations for your kids, but it doesn't mean it's a law. You know what I mean? It's a little bit different. And to be very clear what needs to be a recommendation and what actually needs legislation. And when I think about the limited resources and the efforts and the opportunities that we have as a board, I'm going to look at the data and I'm going to say, where are we having a lot of problems? Where are we spending all of our resources? Where are we seeing a lot of people getting in trouble? And I'm going to focus my resources on those things first. So I hope you don't mind me saying all this, but I just always want to make sure we keep our eye on the big picture and look at the level of principle in what we're doing and not just get lost in all of the details and maybe we should do this and maybe we should do that, if you know what I mean.
Yes, I actually do. And, again, these are good policy points to make. As an attorney for the board, we do have to implement the law as currently written. So if you want to make any changes, that would be a discussion for another day. And I do appreciate the input regarding that. I think that the current law is that we are required, the board is required to develop minimum standards for administration of IV therapy. If the board thinks there's enough education and training and they don't need to put regulations forward at the future, that would be a discussion for another board meeting. But for now, I think my strong recommendation is to go ahead and do our due diligence as best we can to implement the law that the legislature provided you. And if during the course of that, information comes out about where you want to go in a different policy direction in terms of the law, that would be something we can revisit at that point. But if we don't make the effort, I have seen some adverse consequences for not implementing the regulations that that they expected you to do when they gave you this authority. So I wouldn't recommend not pursuing regulations at this time, even if you end up deciding to do something different.
Yeah, and
or
I
recommend
wasn't
something.
suggesting that we would do
Okay,
that.
okay. I just wanted to make sure we're all on the same page.
No, of course we do the basic safety stuff and all of that, just to be very clear.
Okay.
I think, forgive me, I think I have some frustration with the amount of time that we've had this on our docket.
I know, and I do apologize for that. I wish I'd seen it sooner.
That's okay.
It
It's
wouldn't have
better.
wasted your time.
It's
Yes,
better to
I
do it
agree.
before we got in trouble. So we appreciate it very much. Thank you.
Thank you.
Dr. Davidson, did you have comments or questions? Looks like Dr. Davidson lowered his hand, but that Dr. Yoon raised hers.
Here I am. Here I am. Sorry, I forgot to unmute. I lowered my hand, but I forgot to unmute. May I go ahead?
Yes, you are first in line. Go ahead.
Hi, thank you. This is Bruce Davidson. Thank you very much for your analysis and your recommendations. I have a question and a comment. I'm a public member of the board, but I also have a background in healthcare and spent the bulk of my professional career focusing on quality of care. And so I guess my question is, are there currently no minimum standards regarding IV administration that are in place in the realm of the documentation that the committee has authority over?
I'm not sure if there's this private standard setting body out there that has them. I mean, I know the profession has standards, as the prior member D'Amico mentioned. There are standards. They train in school. They learn those standards. What you as a board though have to decide is what those minimum standards, because sometimes schools will go beyond the minimum standards in training. What are the minimum standards for safe IV administration in practice? And we want to make sure everyone's doing the same thing. So the legislature said, to make sure that everyone's performing at least at the minimum. You can always go beyond, of course. The board needs to put these out and make sure that people at least adhere to the minimum standards for IV administration. And it enables the board to more easily enforce violations for failure to meet those minimum standards. So typically in an enforcement case, we would have to put on expert testimony of what the standard of care in the community is. There could be differences of opinion, but if you have a reg, it's like, that's it. Discussion over, that's it.
Okay,
right? So it's easier to administer that way in that regard. But remember, D'Amico's correct. We don't always have to have them in order to enforce the law, because the law is you have to meet the minimum professional standards in the community, right?
Right.
For that safe practice.
So this would be the major difference here would be that that would be extended to a level of detail and specificity, so that a specific minimum standard for this specific thing
has to be, no matter what, and there's no arguments and there's no conflicting battle of the experts kind of thing in cases, right?
Okay, yeah.
You don't have that. It's just, that's it. Got to do it.
Okay.
So in that regard, it makes enforcement easier, but it is time consuming, and there's a lot of engagement you have to do with the regulated community to make sure you get the standards correct.
Thank you. Yes, yeah, and
Right.
I do know from my own professional experience about processes that are followed for the development of evidence-based guidelines and standards of practice.
Mhm.
And so there are, in fact, well articulated frameworks for doing that, and it does generally involve a certain amount of effort to make sure it's
Oh
done
yeah,
properly. Yeah.
it's a lot of work. I mean, I mean, just my experience with infection control, that's just one subset of
Right.
this topic.
And then I
It's
guess I would
extensive.
say that, yeah, that's true. And then I guess I would say that given the fact that IV administration is fairly ubiquitous and across the various clinical professions, there must be a lot of examples of such standards that are out there that have been developed through evidence-based analysis from the different interested parties that could be used as a starting point.
Yeah, I think, all this we'll have to discuss with the advisory committee to see. We got to be careful though about copyright too. So we've got to be, we can look at a lot of different ideas, but at the end of the day, it's going to be the board's standards at the end of the day. So, um, again, I don't have as much background as the members do in this area, so I'm going to defer to them on what needs to be in there. But I kind of know what it looks like generally in medical practice because I've worked with all the different healing arts boards in the department. So, Ms. D'Amico, I don't know,
Okay,
Chair
thank you.
Thompson.
Yeah, thank you very much. I have asked my question and gotten a good discussion going here, and I appreciate your engagement on this. So thank you.
You're welcome.
I believe Dr. Yoon is next.
Oh, okay.
Thank you so much. I feel like I am a little overwhelmed at this process right now, just eye-opening. So thank you for your
Oh.
insights. I think it's great. I just wanted a little bit more clarification from what I'm hearing because what it sounds like is that any training requirements should not be in regs, but you were mentioning how any IV administration, if we're covering site selection or infection control, but if that is part of the regs,
Mhm.
are you saying that if we make a standard for infection control and have people go through, let's say, a certification process, like or a training, would that not be covered because that should not be in the regs?
Well, the statute sort of prescribes what the two criteria are for a
Right.
naturopathic doctor to administer. So I think it'd be harder for us to say, oh, you have to do more training when it says you got to take a 25-hour, and it's not small, 25 hours is a lot of hours, course that contains all these different subject matter areas. I think, if you look at the ledge history, the legislature was pretty much in agreement with this board that the profession could do this
Mm-hmm.
with maybe just an additional course. And they felt comfortable that they could administer if they met these criteria. What we're looking at is in this day-to-day practice, what do we expect you to maintain to ensure that people don't get sick, don't have adverse reactions? And things like personal protective equipment requirements, things like that, what autoclave, who knows what, these are things that I've seen, in other regulations for other boards when they have this delegation where they have to specify the minimum requirements for infection control. And a lot of the healing arts boards have done them. But this is broader and it covers a lot. There's a lot that goes into IV administration, as you know. So there's a lot of different topics we'll be discussing, but they have to do with the actual practice,
Okay.
not whether you have enough. They already presume they have enough education and training because it says that the regulations have to be consistent with the education and training that they've already received, right?
Okay.
So they understand, and there's a nod to the fact that they've gotten this training, but what we're trying to do is make it a standard that they continue to meet after they get out of school. They continue to meet that standard and they know that that's the standard. and everyone is in agreement through notice of the regulations that these are the minimum standards you have to meet in order to have safe practice.
Perfect.
So
Thank you so much.
that's what we're going to be looking at. Like we were talking about, you know, if you look at that paragraph from the assembly analysis, it says site selection is also important because the effect of the medication can be enhanced or diminished depending on the site used. In terms of IV administration, infection is the biggest risk because the skin has been broken, giving bacteria access to the body. In most cases, infection is localized, appearing only at the IV site. However, bacteria can spread throughout the bloodstream. Other risks include embolism caused by blood clots or air bubbles. So, as a practitioner, what do you do to make sure that doesn't happen? There must be some protocols or procedures you do to make sure that doesn't happen. And I'm sure all the naturopathic doctors can chime in on what those are, but we need to put them in a reg so everyone's like, oh yeah, well, you think, oh, it's common sense, they should know it, but the legislature is saying, we want you to put that in writing. So we're all on the same page. That way, they may have been trying to address the opposition to this new professional practice authority. I think that's what they were trying to do. They were trying to say, hey, okay, we hear the adverse comments on this bill. We're going to put in a requirement that this board put in these standards. Down the road, maybe you don't think you don't need them because everyone's doing okay and you don't have any issues. But for now, this is the charge we have. Let's do these minimum standards that we agree that the profession has to meet in order to safely administer. So again, I mean, I don't have the depth of knowledge that the professionals do on the board, but I'm sure you know what those standards are. We just have to write them down and adopt them.
Great. Thank you so much. I really appreciate it.
You're welcome.
So informative. Dr. D'Amico, did you have something else?
Yeah, just, you know, and visualizing how this could go forward. As Christy said, all of what we need to make regulations on is usually taught in the courses that they already are receiving. In fact, they usually will go over the minimum, or
Right.
they often will go over the minimum. So we can use curriculum from the schools as a resource in determining what the content of those regulations should be, because they've already been taught what that minimum is. They've also been tested on it. So we could even use NPLEX questions as another source, as well as looking at what the guidelines are at large in the field of medicine in our state. So just a thought for the subcommittee going forward.
Thank you. Rebecca?
Hi, thank you so much. I just wanted to bring to the attention to the board that during our sunset review and that bill that went forward gave the board the ability to require additional NPLEX exams, and there is an elective exam that NABNY and NPLEX put on that is the parenteral course, and that is something that if you guys wanted to, you could do because it is in our statute now. So there is some way that you guys could ask for additional education to make sure that they're competent in the minimum requirements for IV therapy. So there is that.
Thank you for that, Rebecca. I had actually forgotten about that test being added.
Yeah, so I think that what we're looking at implementing overall is just subdivision D of 3640.8. And so if we want to go into the other areas, I think that would be a discussion for another day potentially. But I mean, I think the request would be that in light of our discussion that the board refer this proposal back to the advisory committee for further review and development and consultation with Regulations Council, and to bring back a new proposal to a future meeting for board consideration. And we'll take all of the comments and input into consideration when we're having those discussions. Any further questions on anything?
I think that process is clear. And, you know, certainly all of us are groaning inward because of the several years that we've been back and forth trying to work on this language, but we absolutely appreciate your insight and helping us move forward.
You're welcome. And, you know, if we can get things rolling and everyone's available, you know, it could take, you know, a year maybe to get everything done, if I'm being optimistic. And we don't have too many roadblocks, but I think, you know, it's just a matter of knowing where you want to go, I think is probably half the battle. Once you're there, then it's just the going through and teasing out the minimum standards. That will be the time, will be a lot of work, but it can be done with dedication to the purpose. And again, that doesn't mean that you're not free to pursue other policy objectives while we're working on it. Right, the regulations, we want to show that we're doing some work and making progress, though. So no matter what you do on the policy side, where you end up on that, that would not preclude us from continuing to try to show that we're doing our due diligence and implementing the tasks that the legislature gave us, or gave the board moving forward.
Thank you so much.
You're welcome.
Are
And, you know, if you, for a future agenda item, I can do like a mini rulemaking thing so you can see, like, lift the, you know, shade from what it looks like, actually what we do under the law, if you're interested. Just so board members can better understand what the rulemaking process is and why it takes so long.
I think that would be very helpful. Are you also the person who is discussing B, the discussion and possible action to initiate rulemaking to adopt Title 16, Section 420, delegation of functions? Is that
4201? Yeah, that would be the next item, but I still would like, if you wouldn't mind, a motion from the board, if someone's interested in making one, to refer this proposal back to the board's advisory committee for further review and development and consultation with Regulations Council, and to bring back a new proposal to a future meeting for board consideration.
I would motion that. Does anyone second?
I'll second. This is Dr. Greta.
I will go ahead and take a roll call vote. Dr. Dar Thompson.
Aye.
Wait, you need to take public comment. I'm sorry.
Oh, thank you so much.
I don't know if we have
No,
any
I was,
public again, Michael.
Christy, I was
do we
about
have
to
any
make a
public?
record that there's no public in the room, so we can.
Oh, there isn't? Okay.
Thank you.
Okay.
Dr. Dar Thompson.
Aye.
Dr. Greta Tomiko.
Aye.
Dr. Vera Singleton.
Aye.
Dr. Bruce Davidson.
Aye.
Dr. Mina Yoon.
Aye.
And Mr. Andy Yam.
Aye.
Thank you very much. And this moves.
Thank you. Appreciate it. So with your permission, Chair Thompson, on to item 5B.
Yes, please. Thank you.
Okay, so we do have I believe, a reg proposal that would be ready for possible initiation, and I'm bringing it to your attention after looking at your regulations. I noticed that the board did not have a delegation of functions regulation for its executive officer. Okay, yeah, there we are. So the proposal covers the functions that are performed by your executive officer. So the current provision in your law is a Business and Professions Code section 3621E, which provides the board may appoint a person exempt from civil service who shall be designated as an executive officer and who shall exercise the powers and perform the duties delegated by the board invested in the executive officer by this chapter. So the chapter doesn't really provide any detail about what the executive officer's functions are, other than supervision of a staff person. The regulations currently have addressed 6 different functions that you've delegated to your executive officer, including complaint disclosure, issuance of citation and fines, setting fine amounts, the contest of any citation, granting extensions of time for correction under orders of abatement, and issuance of citations for unlicensed activity. But as you know, your executive officer does a lot more than that. And there are also some legal provisions in the Administrative Procedure Act that require us to show what's called separation of function between the jobs that your executive officer performs in enforcement cases and what you do as a decision maker in enforcement cases. So I provided you some examples of other healing arts boards in the department that have a regulation that specifies what those functions are and what the executive officer is authorized to do under that delegation. So if you wouldn't mind turning to the proposed regulatory language, attachment, I'm not sure which attachment. It should be attached to the memo, but I'm not sure where it is on the.
8.5B1.
Thank you, B1. So if we could, I don't know, is there a way to show that on screen at all or no? Sorry for throwing that a curveball there to the IT or solid folks. Is there a way to show that that text or not? Okay, well, if you all can turn to that in your packets, the proposed language, whenever we do a regulation, changes are shown in underline when the text is it's new and it's not current regulation, not current policy of the board. So when it's underlined, that's the proposed idea. It's not existing. When it's existing, it's not underlined in the proposal. So when it's struck through or it's not underlined, that's existing regulation. When it's brand new idea, completely underlined, just for background. So the new proposal would be to add a new section to your regulations 4201 titled Delegation of Functions. And subdivision A says, in addition to the duties delegated to the executive officer pursuant to other sections of this division, those are the sections that I just mentioned. You've already done regulations on that gives your executive officer, discretion to do certain things. And that is in the 6 different provisions I just mentioned. So the beginning of the proposal, if you could scroll up a little bit, we can see the text. I don't know.
I think the scrolling can
Oh,
be
it's
done
back
on
to
your own
me.
computer.
Thank you. Sorry, I am like the least technologically proficient person in this room, probably. So, all right. So see this beginning part here, in addition to the duties. Okay, so that's just a nod and a recognition that you've already done some delegation to your executive officer. And then the rest is kind of her daily job functions to plan, direct, and organize the work of staff, attend board meetings and hearings, consult with and make recommendations to the board, dictate correspondence, and attend meetings of various organizations and associations. So there's that subdivision. The second subdivision deals with a requirement in the Administrative Procedure Act, and that's the law that governs both rulemaking and also what we call adjudicative proceedings, and those are your enforcement cases. And one of the requirements of the law is that when we have enforcement cases, 11425.10A4 of the Government Code is in the Administrative Procedure Act, and it requires that for every agency, the adjudicative function, which is your role as kind of like a quasi-judicial role where you kind of act as a judge to decide your cases, has to be separate from the investigative, prosecutorial, and advocacy functions. And so the role of prosecutor is filled by your executive officer. And you're complying with that requirement right now. Your executive officer is performing that function. But this is notice in regulation of that role, where she files the accusations, which are the charges, issues the notices of hearing, statements to respondents, receives and files notices of defense received by any licensee or applicant, sets hearings, calendars cases for hearing, and performs any of the other ministerial functions required to advance your enforcement cases through the process. And this is recognition of that role and your current compliance with the Administrative Procedure Act. So it's just formally recognizing that in regulation. She's already doing all of this, but this specifically acknowledges that role. And then the last part of the subdivision deals with regulations. The other part of the Administrative Procedure Act governs how we do rules. And so by law, rulemaking is vested within the power of the members, the board members. And however, there are situations where we have grammatical, technical, non-substantive changes that need to be made. There's, something's plural when it should be singular. Another example, which you currently are dealing with, is in your regulations refer to you as a committee. You're no longer a committee, you're a board. So you'll notice in this regulation, I had to use the California Board of Naturopathic Medicine board, because your current regulations where this is going to be dropped in still refer to you as a committee. Those need to be cleaned up, and all those titles need to be changed. And there's about 70 plus that I've seen in your regulations that the name change needs to be made. But the staff will have to prepare that and bring it back to you for a vote. But if you do this delegation to your executive officer to allow her to make those changes, they're called, without regulatory effect, meaning it doesn't affect the rights or responsibilities of any licensee or applicant or stakeholder. It's just correcting things like the title of the board, non-substantive changes, anything that's outlined in section 100 of the California Code of Regulations at Title I. Anything that falls within that bucket of non-substantive clarifying changes would be delegated to your executive officer. So she can do that on an ongoing basis without having to wait for a board meeting to do it every time. If it's a standing delegation, she can just clean them up as she sees going forward. And the Office of Administrative Law has a process for filing those requests, and she could just file them without having to come back to you every time. So that's what this proposal would do. If you agree with those recommendations, you have any questions? Yes, I will defer. I will put this back with the chair for further discussion by the members.
So thank you. That again, so appreciate your detail and identifying these issues. I think I'm a little confused about sort of next steps on making these changes. You've given us language.
Right.
Is this something
Okay.
we would be able to adopt today? I'm not saying we should discussion first. I just want to understand logistically.
Right. So just for a process perspective, I wanted to first get feedback on whether there's any problems with the proposed, like the substance of the proposal. But the process is that we bring a concept to you in underline or strikeout so you can see what the changes would be if they were adopted. If the board agrees with them, they would make a motion, and I have the action requested on page 3. Motion A would be the, now if we could stay on the text, please. So if we can, if you go to your board meeting memo, page 3, there's 2 motions. One is, if you don't have any concerns with the way the text is written, you would pass this motion, and the motion would be to approve it as written for section 4201, to authorize us to submit it to the director, because that's the process. We go from you to the director, the State and Consumer Services Agency, Business Consumer Services and Housing Agency. Their counsel has to sign off on it. Then it gets submitted to Office of Administrative Law. They post it for public comment. We get adverse comments. It comes back to you. If there are no adverse comments, then the recommendation that the executive officer proceed to adopt it on your behalf, and then it becomes regulation and essentially law for the licensees and everybody affected. So motion A is approve the proposed regulatory text as written, essentially submit to the director, the Business Consumer Services and Housing Agency. And if there's no adverse comments, authorize the executive officer to take all steps to begin or initiate the rulemaking process, make any non-substantive changes, again, because she doesn't have the authority to do it on her own, to the text, meaning grammatical, other changes, and set the matter for a hearing if requested. So this proposal would go forward. If there's no hearing, it would continue through the process for public comment. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the regulations as noticed. So at the end of the process, you would adopt, and then it would be submitted to the Office of Administrative Law. They would decide whether they think it meets the 6 standards for regulations: authority, necessity, consistency, non-duplication, reference, and authority. And so I think that the motion A is, I'm fine with the text the way it's written. Let's move it forward. Sub motion B is, if you don't like something in the proposal, you want to change it, then we would have to go by motion to an agreement from the board to remove or add or change the text. Then we would proceed with the rulemaking with the amended text. Does that make sense? Or did I just completely snowblind you?
I
A
think
lot
that
of
makes sense.
information.
Dr. D'Amico, you had a question?
Thanks. Yeah, I just had a quick question about the word dictate in there, dictate correspondence. When I first read it, I thought, does that mean she can't type it? Or is that like a legal word that means cause something to occur in
It's
any
not,
form?
it usually, I mean, it's kind of an old fashioned term, but basically it's create or create correspondence. You could
Or
change it to create.
cause to be created in some way by
Well,
even
I don't
another
know. I mean, this
person,
is
right?
from, I think we borrowed it from other examples and they got through. So we were like, okay, it worked. But if you don't like that word, we
Well,
could
if it's
certainly.
understood and not going to give us trouble, I'm fine with it. I
So
just
let me look up.
found that curious. Hmm. So you don't anticipate any issues with her asking someone to write a letter on her behalf that she would sign, or
So dictate means prescribe. So we could say prescribe correspondence, because it could be either her or through an intermediary that
okay,
correspondence
as
goes
long as
out.
that is the
Sometimes,
definition, that and that one constrain her to any particular way of corresponding, then we're good.
no,
Okay.
no, it means prescribe. And OAL will presume that we need to use the word as it's ordinarily used, which is in the dictionary, unless we define it differently. So if we don't define it differently, then it defaults to the dictionary definition of the word. Is everyone okay with dictate, or we want to change that?
It's good.
Okay. Yes, Ms. Thompson, did you want to see if there's anyone else that wants to speak on this?
I do. I also just want to let everyone know that Andy needs to step off, as we mentioned earlier. So we just want to thank him for being here and look forward to seeing him at the next meeting. And then it
Thank
looks
you.
like, yeah. And then it looks like Rebecca does have something to say.
Thank you. Christy, I just wanted to check in with you on whether the board would want to put in any reference to section 820s in this section.
Okay, so I'm not sure if the board's familiar with it, but if you look at the example on page, should be page 2. I don't know why the the header on there didn't look like it picked it up, but it's page 2, Board of Behavioral Sciences they've delegated to their executive officer the authority to issue orders compelling an evaluation of a licensee's physical or mental condition in accordance with Section 820 of the Business and Professions Code. So that's a provision that lets the board compel a psychiatric or physical evaluation to see if it affects they have an issue affecting competency. So you can have a disability or an issue that doesn't affect your practice, and there wouldn't be grounds for discipline. But if it affects your competency and you can't use any accommodation to address that disability, it's grounds for your license, for a Healing Arts Board license, to be revoked or disciplined or an application denied. So some boards, like the Board of Behavioral Sciences, have delegated the function of issuing the order because the courts have said that such evaluations are considered investigative. And so you don't want a board member signing an order and then voting on the case ultimately because they were sort of part of the prosecution side or investigative side if they signed that order. So delegating it to your executive officer can remove an argument that a board member should not be voting on a case for which they ordered a psychiatric or physical evaluation to be compelled on by order of the board for a licensee or an applicant. Some boards still have their board members do it, but that board member would be recused from voting on the case when it came before the board. So that's how they've dealt with it. So you can either delegate it to your executive officer or you can keep that authority. And you would have to have someone, whoever signed it on from the board, would not be voting on the case. So it's up to you on that one. We didn't include it, I think, because not all the boards have that delegation. I wasn't sure how comfortable you were with that. But if you are, we could add that provision in the language.
Dr. Singleton?
Thank you. Does that mean if we do allow that designation to the EO, does that mean that the board itself would not be able to veto her suggestion if we disagree with it?
No. All it does is allow her to order the evaluation to be done. The results of the evaluation would come back to you in the form of an accusation, or because what happens is it's evaluated by her to see if there's charges should be brought. She brings her recommendation to you by way of accusation or statement of issues, and then the board would say, I've read it and I don't agree with that. And you could, take a different route. So no, only thing it would do would mean that when there's an issue that's come forward either by way of complaint or other evidence to your executive officer, she could act quickly to issue that order in consultation with the Attorney General's office, because they're the ones that give advice on enforcement cases. And it's ordered by her. But the decision on whether the license should be revoked or denied still stays with the board.
Understood.
That still comes back to you. Yeah.
Rebecca, you had something to say?
Yeah, I just wanted to give you guys a little bit of background. This is used a lot in complaints where there is alleged substance abuse. So we can have somebody go in and see if they are fit for duty. So this is just something that is done quite frequently. And we've had it done before here at the board. And so I just want to make sure that if this is something that you guys are okay with adding to this section, that it really does reduce the time that a bad actor may be out there under the influence practicing on their patients. It's just a lot easier to get that ordered instead of coming back to a board member and trying to get, that done that way. So I just wanted to add that.
And my other concern, this is Dr. Thompson, is that our board has been sort of chronically underpopulated. We have a lot of missing spots. And so to take one person out of a vote, we could easily lose quorum.
This is Dr. D'Amico. I agree that we should add that provision.
Okay, well then I would need, if you want to make a motion to add the following language to subdivision A in front of and attend meetings. Issue orders compelling an evaluation of a licensee's physical or mental condition in accordance with section 820 of the Business and Professions Code. So
I'm sorry,
does
Christy,
anyone want to?
where did you say you were adding that to?
So see how it says in subdivision A, consult with and make recommendations to the board, dictate correspondence, semicolon, and attend meetings?
Yep.
I was thinking of putting it there, unless you want to put it somewhere else in sub A, because sub B deals with the whole APA process and rulemaking, and it's kind of, I think it might be kind of lost in there if we put it in B. I was thinking of putting it in A.
Okay.
Does that work for you all, or do you want to put it somewhere else? And the language, it would be, if you look at the Board of Behavioral Sciences language, it's issue orders compelling an evaluation. See that? That's that partial sentence there.
I absolutely trust your placement of where that should go in the language.
Okay. Does anyone want to make the motion to add the subdivision A, issue orders compelling an evaluation of a licensee's physical or mental condition in accordance with section 820 of the Business and Professions Code to the proposed text?
I motion. This is Chair Thompson.
I second that. This is Dr. Singleton.
Okay, again, I don't know if we have any public at all yet.
Is there any public present?
This is the moderator. We have two DCA staff. Would you like me to open up?
Yes, if we have public present, please do open.
We have two DCA staff.
Oh, I'm so sorry. Does that
I don't
not?
know, it's
Our attorney said that they weren't considered people of the public.
Fantastic.
Well,
So
I'll just let you know that I've had some feedback from DCA on this. They may want to comment. That's my only concern.
let's open. Let's not miss that. So let's open for public comment.
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. If you would like to participate, click on the question mark inside the square, typically lower right corner of your WebEx screen, and type the word comment in the text field that appears, and make sure it goes to all panelists before you click the send button. You can also raise your hand by clicking the outline of a hand, which is typically the bottom center of your WebEx screen on the command row. At this time, I see no requests coming in through the Q&A and no hands raised. Would you like me to close the Q&A feature?
Yes, you can. I'm getting a notification from Rebecca Mitchell that our budget team is going to need to leave soon. So
Dr. Thompson, this is Dr. D'Amico. I have a question for Christy before we move on. Would that be okay?
Oh, absolutely.
And I need another motion too, so.
Yeah, we've got
need another
several
motion.
things going on here, but I just want to flag people that we do have a time constraint on getting the report from the budget committee. So we also made that motion, but we haven't done a vote on it. So Rebecca, do you want to do the vote on the motion that we just made?
Sure, I have a motion from Thompson. I have a second from Singleton, and I will call roll. Dr. Dara Thompson,
Aye.
Dr. Greta D'Amico,
Aye.
Dr. Vera Singleton,
Aye.
Dr. Bruce Davidson,
Aye.
and Dr. Mina Yoon.
Aye.
Great, thank you. And that passes with 5 ayes.
Okay, so the final thing, final motion I would request is that the board approve the proposed regulatory text for section 4201 as provided in the attachment and as amended at this meeting. In addition, submit this revised approved text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the text in the package, and set the matter for a hearing if requested. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noticed for 16 CCR section 4201.
This is Dr. Yoon. I'll make that motion.
This is Dr. D'Amico. I'll second.
All right, can we do a roll call or do we need a public comment?
Do we need a public comment because the DCA employees?
I would just check and see if they want to comment on the overall motion to move this proposal forward.
Moderator, can you open a comment box for that?
Yes, this is the moderator. The Q&A is now open. And let me put the instructions here on the screen for you. There you go. Instructions are on the screen. Click the question mark, type comment, or raise your hand by clicking the outline of a hand, which is on the command row, the center of your WebEx screen. I am not receiving any requests. Would you like me to close the Q&A feature?
Yes, please. And Rebecca,
Yeah,
can you do
take
a
a-
roll call vote?
Absolutely. Dr. Dara Thompson,
Aye.
Dr. Greta D'Amico,
Aye.
Dr. Vera Singleton,
Aye.
Dr. Bruce Davidson,
Aye. Aye.
thank you. Dr. Mina Yoon.
Aye.
Great, and that also passes with 5 ayes. Thank you.
Okay, and then Chair Thompson, I don't think I'm needed for the rest of the meeting unless Ms. Mitchell thinks I do need to stay. I'll excuse myself if that's okay.
This is Dr. D'Amico. I had a question, Christy, for you.
Oh, you did?
if
I'm
that's
sorry. Go
okay.
ahead.
In the supporting materials we got in our packet, we received A5A2, attachment 2, whatever that means. So this is a hearing from June 19th, 2012 on the Assembly Committee, BNP. And I don't know how this fits into the bigger picture of what we discussed today, but I noticed on page 2, number 4, that it says defines for the purposes of the qualifying course required by this bill, 1 classroom hour as 50 minutes out of each segment, 60-minute segment, this is in school, which may include time devoted to examinations. No credit shall be granted for distance education, including but not limited to correspondence courses, internet courses, or video or remote television offerings.
Yeah.
That really caught my attention because of the evolution in education that's currently occurring. Is this actually part of our statute currently?
Yes. Yes, and
Um,
it relates to the prior agenda item on the IV administration regulations. So I would suggest that this be discussion may be for a future agenda item on whether there's anything that
Yes.
needs to be revised within 306040.8 because
Yes,
yeah.
I'd like to ask our executive officer to please do any research as appropriate and put this on the next agenda.
Thank you.
Thanks.
So, Christy, thank you so much for joining us. I really appreciate your input and look forward to working with you further. I don't see anything else you're needed for on this meeting. So if you need to go do other things, we'll just look forward to seeing you again soon.
All right, thank you so much. Take care. Bye.
Bye now. All right. And at this point, I would like to move on based on our time constraints to the report by the Budget Committee. I know people are probably hoping for a break soon, but let's let these people get their report done so they can go on to their next event.
Thank you. I appreciate that. We'll be doing a presentation on agenda item 6F. Christina will be going ahead and leading us off.
Good morning. My name is Christina Ritchie. I am a budget analyst with the DCA Budget Office. First, let me thank the board and executive staff for allowing me a few minutes to present the fund condition statement, revenues and expenditure projections. Also with me is my budget manager, Renee Milano, who will be available to answer your questions at the end of the presentation. As she said, please refer to agenda item 6F. These documents are what I will be discussing today. They will provide a lot of information on the board's budget, both revenue and expenditures, and the projected fund balance into the future. I would like to highlight some of the information and provide a little more clarity on them. So for the board's expenditures, I believe page 1, personal services approximated to be 301,000. Operating expenses and equipment was approximately 84,000, and total expenditures were approximately 377,000, which includes approximately 8,000 in reimbursements. Reversion percentage is approximately 2.5%. And then for the board's revenue, total revenue was approximately 566,000. Now for the board's fund condition, page 3 of the document is the board's fund condition statement. We read this document top to bottom and then left to right.
Can you
The
please
left
say
column-
again what the attachment is for this? I'm trying to find it.
So it's agenda item 6F, and the board's fund condition is the 3rd page. Board's revenue is the 2nd page, and then board's expenditure is the 1st page. So right now we should be on page 3. Is everyone good?
You.
Everyone look good? Yeah.
I think you're good to continue, Christina.
Okay. All right. Okay, so for, so we read this document from top to bottom, then left to right. The left column is PY, also known as prior year or past year. The board began 2021-22 with an adjusted beginning balance of 638,000 and collected approximately 553,000 in revenue and expended approximately 374,000 in direct expenditures and additional statewide expenditures for a total of 42,000. The board ended the 2021-22 with approximately 758,000 in reserve balance, or about 22.5 months in reserve. This balance moves to the top of the next column of the fund condition and becomes the beginning balance for the next fiscal year. Months in reserves is the amount of time the board can continue normal operations without any incoming revenues, and a healthy board is considered to have at least 6 months in reserve funding. For 2022, 2022-23, the current year. Based on the latest fiscal month 10 data, the board projects an estimate of about 566,000 in revenue. This number is estimated to remain stable over the next few fiscal years. The board expenditures for this fiscal year as of fiscal month 10 are projected to be approximately 377,000. As with revenue, expenditure projections may change with actual returns in the remaining fiscal months. The budget office will continue to monitor these expenditures and report back to the board with monthly expenditure projections as the future fiscal months close. You will see for 2023-24 and ongoing years, the projections for revenue and expenditures. There's a few things to note of the fund condition. The fund condition is a snapshot in time and thus only a reflection of the data used in its creation. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. This includes general salary increases, as well as employee compensation and retirement rate adjustments. The budget office includes an ongoing 3% increase to expenditures on the fund condition statement to account for those ongoing incremental adjustments. Months in reserves will always go down in out years as we project revenues to remain constant and expenditures to increase by 3% previously mentioned. The budget office will continue to monitor the board's fund condition statement and keep the line of communication open with the boards and executive staff for any future needs or expectations. Again, I want to thank the board members and executive staff for inviting me to today's meeting, and my budget manager, Renee, is available to address any questions you may have.
Are there any questions from the board? I don't see any questions. Are there any members of the public present for public comment?
Madam
Moderator,
President, there are no members of the public present. Thank you.
Wonderful. Well, I really want to thank you for your presentation. It doesn't look like we have any questions for you at this time.
All right, thank you very much.
Rebecca, would you recommend at this point we go back to the beginning of agenda item 6?
Yes, we can definitely do that. Did anybody need to take a break, or are we free to move forward?
Oh, given the time, it would make sense to take a break at noon, so people could get something to eat, etc., rather than at this time, unless, let's just look at the agenda quickly and see what makes the most sense here. Because after item 6, how much do we have left to do? Like, do we want to take I guess the question is, do we want to take a short break now and try to finish the meeting and not do a lunch break, or do we want to push through until lunch and then take a longer break and resume after lunch? Rebecca, do you have a sense of how much longer the meeting will likely run?
Yeah, I'm just taking a look at a couple of things right now. I think we have Rose Turner, who is our legislative manager, and she's here to provide some information as well on some bills that we had in agenda item 8, I believe it was. So if you would like, we can have Rose go now so that we can free up the rest of her day. And then I think the rest of the meeting, I think we can get done within an hour.
So why don't we do that? Why don't we have Rose do her presentation, then we'll take a 15-minute break for anything that people need, and then we'll finish up the meeting and not do a longer lunch break. Is there anyone for whom that is not going to work? Please just let me know now. We can always change it. Okay, looks like that's fine with everyone. So is that agenda item 8 that we're just going to jump over to right now just to accommodate the
That's
schedule?
correct.
Yes.
Yes.
Moderator, can you open up that screen?
I apologize. This is the moderator. Which screen would you like displayed?
Agenda item 8.
Is this sufficient, or would you like the materials attached to the board meeting packet?
I think this is sufficient.
Yeah, I
Thanks.
think this is sufficient. Thank you. All right. Good morning, everyone. My name is Rose Turner. I'm a legislative manager over at the DCA Legislative Affairs Office, Division of Legislative Affairs. Calling it the office, it's not. It's the Division of Legislative Affairs. Here to talk about 3 bills today. We'll start in with AB 765. This bill would have made it a misdemeanor for a person who does not have a valid physician license to use any medical specialty title or any names, terms, letters, words, abbreviations, description of services, designations, or insignia indicating or implying that the person is licensed to practice under the Medical Boards Practice Act. The bill was held in the Assembly Appropriations Committee, and it is now a 2-year bill, and it's dead for the remainder of the 2023 legislative session. It may be acted upon in January of 2024, but it did receive a robust sorry, forgetting words. It did receive a robust discussion and opposition from various groups, including the board. I believe the board's position letter is item 8A3 in your information packet. So the chances are, if it is brought back, it won't be in the same form. It will probably be a little bit different. No guarantees though. Are there any questions board members have on this bill? Or would you like me to hold questions until the end?
Why don't we hold questions until the end? Thank you.
Okay, cool. All right. Moving on to agenda item B, SB 818. This bill would update certain sections of the Business and Professions Code to, among other things, reflect the board's recent name change. The conforming name changes would allow the board to require applicants to do a fingerprint background check, and allow the board to receive the fingerprint background check information from the DOJ and the FBI. It's pending hearing before the Senate Business and Professions Committee, and I've actually heard from someone at the Business and Professions Committee that unfortunately this bill might not move this year, which is a little unfortunate. And lastly, AB 1021. This bill would automatically authorize healthcare professionals in California to prescribe, furnish, or dispense any Schedule I controlled substance that has been federally rescheduled or exempted from the Controlled Substances Act. This bill wouldn't apply to cannabis products that are currently regulated in California, so it would just be other Schedule I controlled substances. And it's set for hearing before the Senate Appropriations Committee on the 3rd. So what, next Monday?
So what would examples of those substances be?
Gosh, so a Schedule 1 substance, so it would, one of the ones that comes to mind would be like psychedelic substances. So
So this would potentially pertain to like the use of psilocybin in psychology and
yes,
things like that.
yeah,
That's
Okay.
correct.
yeah. Rebecca, you had your hand raised.
I was just going to provide some of the substances that would have been under this act, but yes.
Mhm. Yeah.
Hi, this is Dr. Thompson. I'm so it sounds like and just tell me if I'm correct here, with the AB 765, we've already provided our opinion on this, so we don't necessarily have to take any further action. Is that correct?
That's correct.
And so the two that we haven't weighed in on yet are the SB 818 and the AB 1021.
Yes, that's correct.
And so for today, we should decide if we're going to take a stance, and if so, what that stance should be.
Yes.
All right. Members, do we have any questions on these? Rebecca, having looked into these, do you have any specific recommendations on stance?
So I would suggest that you guys take at least a support on the SB 818 since it has to do with our board. On the 1021, you could either do a watch and kind of see where it goes. If you guys are in support of this, I would definitely give that support. I don't see any reason to oppose either one of those two bills.
Can you elaborate on how SB 818 directly affects us?
Sure. So SB 818 corrects an oversight that happened when the former committee's name was changed to the Board of Naturopathic Medicine. Previously, the board, I think, had the capacity to do a fingerprint background check, but that was effectively taken away because this is basically a conforming name change. So I'm not entirely sure if it is actually taken away. Going back on my words here. But the reference in the code section is to the board, the Naturopathic Medicine Committee, or the Committee of Naturopathic Medicine. I can't remember what you guys were used to be called anymore. That's amazing. It's only been a year. And therefore, there may be some confusion as to whether or not the board still has the authority to conduct a fingerprint background check. This bill, with its conforming name change, would cement the board's ability to do that background check.
Thank you so much for that. Yeah, that seems incredibly vital for us to protect the safety of our consumers.
Yeah.
So thank you for that clarification.
Mhm.
Does anyone else have any questions about that? SB 818. If we're going to provide a stance of support or watch, etc., do we have to do a vote on each one of these individually?
Madam President, yeah, this is Michael. I would recommend a separate motion for each measure really because there could be members that may want to vote differently on each one.
Absolutely. Do we need to do, but we don't need to do anything on AB 6765 because we already voted on that, correct? And sent a letter.
Yeah, if you already have a position, you don't have to take any action there unless you want to change your position on the bill.
Okay. Rebecca, what did you have to say?
So I just wanted to advise everyone that Dr. D'Amico had some technical issues and she is trying to restart her computer. So right now, as of this moment, we do not have quorum to take any motions. But as soon as she gets back on, if you guys would like to take a motion on this, you can.
This is Dr.
Madam President, I'm sorry to interrupt, but if we don't have quorum, my recommendation would be that we go on to a break until we have quorum again. An individual member needs to hear the discussion and the complete discussion when there's going to be action taken on a matter, especially. So I'd recommend that we pause at this point until we have quorum again.
She's back
It
on.
looks like I just popped back on, but
Yeah, this is Dr. D'Amico. I came back on as you're about to take a vote, but I did miss from the moment Rose started speaking. I did not hear anything. I'm sorry.
okay.
If other people want to take a break, you can give me a private presentation, a summary.
Michael, am I allowed to do that?
I think we can, no, I don't think we can have an offline here. And that would be very helpful. I agree. But
Well,
perhaps Rose, you could give a summary, maybe not as
Okay.
in depth as your original report. You
Sure.
can give a summary and we can sort of fill in the gaps if we think there's anything there.
I will try to hit the high points. Let's see. AB 765, the board, I believe at a prior meeting, voted to oppose this bill. It is now a 2-year bill, dead for 2023. It may come back in a slightly different version next year, but we're going to wait and see. SB 818 would cement the board's authority to run fingerprint background checks. It's a conforming name change. When the board's name was changed to the board from the committees, these code sections related to fingerprinting were left out inadvertently. And so it just changing the name from the committee to the board. But because there's that, because it's still referenced as the committee in statute, there's that confusion there. So we want to make sure that the change to the board's the correct name is confirmed in order for there not to be any confusion in the future. And the bill is now pending before the Senate Committee on Business and Professions and Economic Development. AB 1021 would automatically authorize health professionals in California to like it automatically flips Schedule 1 drugs or drugs that were previously federally Scheduled 1 to whatever schedule they would be then considered under a federal schedule to the most appropriate schedule in California. So like if I think the example I used before was like psilocybin suddenly became a got removed from the federal Schedule 1 Controlled Substances Act and got placed onto a different schedule or exempted from the Controlled Substances Act, then it could be prescribed in California under whatever federal requirement or federal schedule it was placed under.
Okay, this is Dr. D'Amico. Did you
Sure.
discuss regarding SB 818? So this is already a bill that's being considered, correct?
Yeah, all of these bills are currently being considered. These are all pending currently.
Okay. And we just approved language that would allow her to make those changes without legislation in the future, the EO. We just did that earlier in the meeting.
So this actually, Greta, this basically right now, because our name changed from a committee to a board, it is questionable whether we're allowed to do fingerprint checks on our licensees. And this just changes it so that our new name as the board allows us to do that again.
Yeah, okay. And yeah, and we'll be taking care of needing to do this in the future with what we did earlier today, because then the EO will be able to change our name for us.
Well, so
Uh,
this is already, this is a
I
pre-existing
understand.
statute.
Yeah, I
And
understand.
so the law is already there, and the law in question says the committee. And
I
so
know.
the bill would just make
Yeah.
a conforming change to reference the board instead of the committee. And the question is, and I think the prior discussion was to delegate functions of the board so that in the future, Rebecca or whoever the executive officer is at the time would be able to support or oppose these types of bills in the
I
future
thought she
without,
would be able to change the name. That would be considered a non-substantive change.
yes,
Um,
Rebecca, sorry.
Hi, Dr. D'Amico. I just wanted to provide some clarification here. So I believe what you are referencing is the ability to make changes to regulations in a Section 100. This here is a legislative bill, so this is a little bit different. This has to do with a change that would be made directly to our statute, not to the regulations. So this is what we're talking about right now. These are bills that are currently in the legislature that are being looked at. As Rose had mentioned, AB 765, which would have taken your guys' ability to use your specialty titles, has been suspended, at least for the rest of this year. Could come out next year. SB 818 that will make that conforming name change for us. Yeah, so these, my suggestion to the board, and I know you missed this a few moments ago, but my suggestion to the board would be to either go neutral or at least support on both of these bills. I don't see any reason to oppose either one of the SB 818 or the AB 1021. My suggestion would be to support both.
I agree, and I have a question. I'm not sure if this is your office, Rose, that would do this, but do you know if anyone has combed through all the rest of the legislation on the books for the word Naturopathic Medicine Committee to make sure that we've cleaned up everything?
It is partially my office, partially it's in conjunction with Rebecca and her assistants, and partially it's with the help of the Office of Ledge Counsel and the joint business and professions committees of the legislature. We try to do it on kind of a case by case basis as things come up. Like this bill was, I mean, this happened relatively quickly after the name change. This is what, the next session after the name change was enacted. So it was a very quick catch. And I think it should be pretty much the only catch there is, although I can't guarantee it. But yes, we do keep an eye out.
This is Dr. Thompson. I have a question, just a clarifying question on AB 1021. So as you said, my understanding is that all that AB 1021 does is say that if something is changed, it doesn't do anything specific for California except say if something is changed federally, it applies to California without there having to be a separate decision.
Right.
Okay.
So, usually what happens is there's a federal scheduling of drugs in the Controlled Substances Act, and then California has its own specific drug schedule that sort of conforms to the Controlled Substances Act drug schedule. And what this does is it says, yeah, if a Schedule 1 drug falls off of the Schedule 1 Controlled Substances Act, then California healthcare professionals can subscribe it, subject to whatever new schedule it's placed under, without necessarily waiting for California to place it under its own schedule that needs to go through the legislative process.
Thank you. Do you know if this would have any impact on local decriminalization of certain substances? For example, I know that certain counties have decriminalized some of these substances, even if they are still federally illegal, such that they've basically said we are not going to pursue or prosecute these at this time. I just want to make sure we're not voting for something which is then going to hold, take away the autonomy of these counties in California from making that
Right.
choice if it hasn't been acknowledged federally.
Right. That gets a little trickier, and I'm not entirely sure.
Mm-hmm.
Because in general, anything on the Schedule 1 of the Controlled Substances Act is federally criminalized, right? So, like, cannabis is a great example of this. It is legal in California. It is certainly decriminalized in California. We acknowledge it as a tradable substance. We can buy it, sell it, whatever. It's not a criminal activity to purchase cannabis in California, but federally, it is still a criminalized substance. So, from that standpoint, if something is taken off of the Schedule 1 Federal Controlled Substances Act, it is federally decriminalized, right? But I can't speak to any local jurisdictions' criminalization or decriminalization of the substance. That's getting into a too nitty-gritty of an interpretation, and at this point in time, I don't have the information for that. I could get back to you on it, but without any further information, I wouldn't know.
For me personally, from what we've talked about, that would be my only concern with this bill, would be that it, not be somehow having some weird backlash saying that California must then comply with these federal standards if people have voted and made a different decision at a state level.
Right. It doesn't seem like that's the case. It's very much like, Michael, your camera went on.
And I was looking for the raised hand feature. It always takes me so long to find those things. I thought I would just jump in. Really, cannabis is really a special case, and this bill specifically carves that out. So
yeah,
there's really the tension that is present at the moment in sort of between state and federal law on cannabis really won't be present here.
Right, and that actually wasn't my question.
Oh, I'm sorry.
No, I think I used cannabis as a poor example because it is decriminalized in California, and so there is that That was the only example that I can think of a
But there
decriminalized
wouldn't,
Schedule 1 drug. Off the
but
top of
for
my head.
other Scheduled one, but if a Schedule 1 drug, some other drug, is taken
Right.
off the schedule, then those sort of federalism concerns where it's illegal under federal law and legal under state law don't arise. That was the point I was trying to make, probably not very eloquently.
Absolutely. And that seems like it's just removing a lot of bureaucratic paperwork. If it is decriminalized federally, then we have to go through all the stuff of decriminalizing it on a, or I'm sorry, rescheduled federally. We don't have to go through and reschedule it on a state level. And that seems great. And my question was more, is there some reverse that would happen where I know that there are certain counties in the state of California which have decriminalized psilocybin, for example. I'm not trying to be some like psilocybin soapbox situation. I'm just using that as an example of what, and so is there anything to go with this particular bill that would say, if we adopt that and it is still Schedule 1 federally, that somehow trumps these counties' decisions to decriminalize that substance? That's my question. And it sounds like we don't actually have the answer to that.
No, there isn't a reverse Uno card in the bill like that.
Okay, great. So that sounds good.
And frankly, counties have no, or local governments have no authority to take action on items like that to make it decriminal, to make it not criminal if there's a state law that that does that. Then the federal interaction is a whole separate question. But just in terms of local government authority, I mean, there may be local governments that do that or say that they're doing that, but I would suggest that those are very questionable.
That might just be more of a practices thing rather than anything. Okay, thank you for clarifying that. So that would need to happen on a state level anyway.
And this is Dr. D'Amico. To be clear, and this is just please correct me because I would like to understand this, because I'm still relying on my government classes from high school, is that, the federal law is the law of the land at the highest level, and that states can always pass more restrictive laws than the federal government, but not more liberal laws than federal laws. So states also don't really have the authority to pass a law that is in violation of a federal law, even though they do it. Is that right?
That's correct.
Thank you.
So moving forward, we have two different bills we need to vote on our stance on, because there haven't been, to the best of my knowledge, there hasn't been a change in our stance for AB 765. So starting with Senate Bill 818 regarding fingerprinting, we have the option to support, to watch. Does anyone have any further questions on that before we vote on taking a stance on this? Rebecca?
You may also remain neutral.
Yes, we can remain neutral. I would motion for a supportive stance on SB 818.
And Dr. Thompson, we might be able to recommend for both at the same time if we want to.
Unfortunately, while you were off, legal recommended that we not do that.
Okay. I'll second your motion. Thank you.
And I still don't see
Do we
any
have
public comment.
members? Oh, thank you.
Okay, I can take roll call for you.
Fantastic.
All right, Dr. Dara Thompson.
Aye.
Dr. Greta D'Amico.
Aye.
Dr. Vera Singleton.
Aye.
Dr. Bruce Davidson.
Aye.
And Dr. Mina Yoon.
Aye.
All right, and that motion moves with 5 ayes.
All right, and then for Assembly Bill 1021, controlled substances rescheduling. Is there a motion on this?
This is Dr. Singleton. I motion to watch this bill.
This is Dr. D'Amico. I'd like to make a motion to support this bill.
So I think we need to first ask if there's a second for the first motion, because we have a motion on the floor. If there's no second, then that motion dies, and then the subsequent motion to support could be made. So is there a second on the first motion to watch the bill?
Would anyone like to second the first motion to watch? Okay.
So at this point, the motion dies and you can proceed with another motion.
All right, and Dr. D'Amico had put forward a motion to support. Would anyone like to second that?
This is Dr. Yoon. I'll second it.
Thank you. Greta? I'm sorry, not Greta. Rebecca? Apologize.
No worries. Okay, so I have a motion by Dr. D'Amico to support and a second by Yoon, and I will go ahead and take roll call vote. Dr. Dara Thompson,
Aye.
Dr. Greta D'Amico,
Aye.
Dr. Vera Singleton,
Nay.
Dr. Bruce Davidson,
Aye.
Dr. Mina Yoon.
Aye.
Okay, and we only have 4 ayes, 1 no. We do not have a motion. No, it does not pass.
Rebecca? So forgive me, but do we have a vote requirement?
It has to be quorum.
I didn't see one. I don't see one in your practice act. So if that's the case, you just need a quorum voting on the motion, and the larger number of votes is, carries or defeats the motion.
Okay. All right. Thank you. We were told something different way back. So, okay, if that is how we're going to do it, then the motion moves with 4-1.
And while I'm at it, just briefly, just making a record that for both of the last 2 motions, there was no public present in the meeting. Thank you.
Thank you. All right. That concludes agenda item 8. I think everyone needs a break. Can we be back at 12:11 to finish up our meeting? Oh, wait, Dr. Singleton has her hand raised. I apologize.
I can wait until after we come back from break.
Okay, great. Yeah, maybe 12:12 at this point. Thank you so much. All right, is everyone back from their break? Rebecca, can you do a roll call and make sure everyone's back?
Absolutely. Dr. Dara Thompson.
Present.
Dr. Greta D'Amico.
Present.
Dr. Vera Singleton.
Yeah.
Thank you. Dr. Bruce Davidson.
Present.
Dr. Mina Yoon.
Present.
Great, thank you. Everybody's back online.
I'm so sorry, I was muted. I apologize. Just talking and nobody was responding. So I believe right before the break did Dr. Singleton have a question that we needed to address?
Yes, I do. I just wanted to get clarification on the issue of our board name change and how that's impacted throughout our regulations. And I understand currently, well, it was brought up before, but I don't think I got a clear understanding of whether we could make those substantive changes across the board under the supervision of Rebecca, or do we have to vote to make all of those changes ourselves as a board?
Hi, this is Michael Kenotes, legal counsel. I thought I would jump in here first to make sure that we stay on the agenda. As it relates to SB 818, any changes to the name in statute would have to be made in statute. But I think that this last bill was a cleanup from the couple instances, or maybe just the one instance where that wasn't accomplished. But there are provisions in regulation that we can change if it's a non-substantive change, but not for statute.
Okay, so we don't have to worry about it as a board. So Rebecca would be able to make those changes without our needing to meet again.
This is Dr.
Across, right?
D'Amico. With what we did this morning, she would be able to make changes in regulation, but not in law. For law, we would have to have a bill.
Okay, understood. Thank you.
Thank you for that question. At this time, I would like to go to agenda item 6, which is the executive officer's update. The only thing we've done on this item was the budget review. So I'm going to turn it over to Rebecca to go through that.
Great, thank you so much. All right, well, I am happy to report to you guys today. We obviously, as you know, we have Andy Yam, who was just recently appointed to our board by the Speaker, Rendon. And that was done on the 26th. And as you know, he joined us for a short time today. So we do have that position finally filled. So yay. However, we still do have 2 positions on our board that are currently vacant. We have one professional member, and that position's been vacant since February of 2022. And we also have one physician and surgeon. It could be an MD or a DO position on our board that has been vacant since, September of 2019. So quite a bit of time. Unfortunately, because we are down one physician and surgeon, it really makes it difficult to do some of the subcommittee work that we need to do. So hopefully we will be able to get somebody in those positions soon. We are working with the Department of Consumer Affairs, Board and Bureau Relations, and the Governor's Appointments Office to get those positions filled as quickly as possible. All right. Can I go down to the next slide, please? One more. Thank you. So on April 1st, 2023, the board relocated to the Department of Consumer Affairs Headquarters 2 building, which is located at 1747 North Market Boulevard in Sacramento. The board currently leases a suite that's shared with the California Board of Registered Nurses Licensing Division. We have finally got all settled in over here, and we're ready to rock and roll. Staff was present. They completed the move of the property to the new site. There were no delays in licensing or enforcement processing. However, there was a slight delay in some of the mail delivery, but within the first 3 weeks after the move, that has kind of got itself sorted out, and all services are now being managed with no delays or challenges. Any questions with that? Dr. Singleton, is your hand still raised, or do you have a question?
I actually do have a question. Is this the same building where we met previously? or it's a different building?
So this is, I'm trying to think if we've ever met over at this building. I believe that you guys may have had a BMOT if you've done the BMOT in the last BMOT, I think was done here. But it's the building right across the way from the headquarters one building.
I see.
Same parking lot.
I see.
Yep.
Thank you.
Of course. Dr. Yoon?
Was there a reason for the move?
Yes, we outgrew, well, we didn't outgrow the space, but the Osteopathic Medical Board had needed some more room. And because we just at the time we were going to from the committee transitioning to the board, and so we figured if it was going to be any time that we needed to move, it was probably better to do it then. Although we did not really want to make the move because fiscally it would have been more responsible to stay there and finish out our lease at the lower rent rate. There was just no way for the other board to do what they needed to do in their terms of business. They had new staff coming in and they just didn't have any room to put them. We definitely outgrew the space. The several years before, when we renewed our lease at that time, we had them build it out as much as it could be built out. Unfortunately, that was they told us at that point that if there was any additional staff, that we just would be at capacity. There was just no way to add anything at that point. So that's why the decision at that time was made to move.
Okay, thank you.
Of course. All right, and if there's no other questions, go to the next slide, please. Okay, so this is into our staffing. During the 2022 Oversight Sunset Review process, the board provided information to the legislature about the ongoing issues with unlicensed practice. Assembly Bill 2685, Chapter 414 of Statutes of 2022 was the sunset bill that changed the committee to the California Board of Naturopathic Medicine, along with providing authority to hire an additional staff member to assist with the large unlicensed activity. Staff prepared a budget change proposal requesting the authority to create an analyst position for enforcement tasks. The position was approved for a full journey level analyst at an AGPA classification. Staff has started working with DCA's Office of Human Resources to develop duty statements and the required hiring documentation for recruitment purposes. And are there any questions on that?
This is Dr. D'Amico. In the attachment, it says that that process has been temporarily suspended. Is that still the case? And if so, why?
So we had just been informed that every board and bureau under the Department of Consumer Affairs has a position in a management level that the executive officer can delegate duties to in their absence. Unfortunately, we don't have that ability. We had been told by one of our legal counsel that we would probably need to seek that. Unfortunately, after speaking with the chief of the Administrative Services Office, Human Resources, and everybody, the suggestion was made to use alternative routes to do that because we just don't have the resources and funding to bring on a management level. We were really looking into that, maybe needing to have that position that was just currently created pulled back and recreated into a management level, but that's just not going to happen. So, and this just came to me yesterday. So unfortunately, we will be moving forward with that process. Are there any other questions? Okay, well, moving along, we will get to the licensing statistics. All right, during the 2022 oversight review, let me see here. I think I am at the wrong place. Here we go. All right, so in the applications received and approved between October 1st, 2022 and June 26, 2023 are shown on the screen at this time. 2023 quarter two, 2022 quarter four, you'll see that we received a total of 188 applications, and that's all in between the license applications, license fee, and then the renewal applications. And then we approved 199. 2023 quarter one, we received 163 total and approved 156 total. 2023 quarter two, we received a total of 247 and approved 128. And I can tell you that the quarter has not finished out for the quarter two yet, so there are still some data that's going to come in for that. So that's probably why we're seeing the big gap in between what was received and what's been approved so far. Are there any questions on this section here? Okay, great. And I can tell you that we are still within our performance measures. We're doing really well in terms of approving those within the time constraints that we should be doing. All right, moving right along. This is going to be licensing statistics as well. This table will show the number of licensees practicing under the board's jurisdiction. The board's total licensee count as of June 26th is as follows. Active and current licensees are 1,001. There is also one suspension right now for family support issue. And once that licensee clears their case with family support court, they'll be placed back into an active status. Currently, we have 27 inactive current licensees. We've got 116 that are in a delinquent status and another 278 that are either in retired or canceled statuses. Total number of licensees within the board's jurisdiction is 1,422. And do we have any questions? All right, moving right along to the enforcement. Unlicensed activity continues to remain the largest portion of the board's enforcement caseload, making up 53% of the cases. You can tell that they have come down quite a bit since we started this process several years ago when they were up in the 80 and 90%. So we do hope that the continued educational and informational outreach campaigns will assist in reducing the unlicensed activity. The board is increasing educational letters to traditional naturopaths that use the ND title without the benefit of a license or who violate the Naturopathic Doctors Act. We have been successful in gaining compliance prior to issuing of citations and fines or cease and desist letters. The unlicensed activity consists of the following violation types. We've got using the naturopathic doctor title, violation of California Business and Code section 3660, not providing a written disclaimer of unlicensed practice to their clients and having a signed copy by the client on file per California Business and Professions Code section 2053.6 and Business and Professions Code 3644, providing diagnosis in violation of California Business and Professions Code section 2053.5, advising their clients to discontinue medication prescribed by licensed healthcare providers, also prohibited within California Business and Profession Code section 2053.5, providing treatment within the scope of an ND without a benefit of a license and causing harm or death to clients. The board has 26 new cases submitted from November 11th, 2022 through June 26, 2023. Staff's been working hard to get complaints closed. Since the last report on 11/10/2022, the enforcement unit has closed 18 cases, revoked one licensee for unprofessional conduct, and currently there are several that have been resolved and are awaiting management review and closure. Since the board's creation in 2004, this is the first time that a licensee has been revoked. Additionally, our board was first nationwide to take action on a healing arts practitioner for violation of the COVID-19 vaccine administration. And do we have any questions?
I had a question about this slide, Rebecca. This is Dara Thompson. I, in seeing the shift of percentages, I'm happy to see that our unlicensed activity is going down. However, is the total number of cases against licensees going up or simply the percentage?
I think it's just the percentage because it's still 53. I mean, it fluctuates between 30 to, 50, depending kind of what we're doing at that point. A lot of them in the beginning was, of course, just small things like address, change of address and that kind of thing that they weren't doing, or somebody didn't meet their CE requirements, those type of things. However, they have been getting a little bit more egregious, and during the next slide, you'll kind of see where they fall into place in those violations that make up the cases against licensees. But yeah, there has been a little bit of a shift, and I think that it really does have to do with the fact that the unlicensed activity, with those that at least are only using the ND title, that they are becoming compliant and not using it. However, there's still the cases against the unlicensed folks when it comes to the actual violation of other things, not including the title.
Thank you. That's helpful.
Of course. All right. And were there any other questions before I go to the next slide? We'll be discussing the licensees cases there. Okay, perfect. Let's go ahead and advance. All right. So this is the information here in the data against the violation types that make up enforcement cases against our licensees and applicants, and they're separated into several different violation categories. Currently, the board, again, has 53 total enforcement cases opened against licensees. Of those 53 cases, the breakdown of violation types are as follows. Advertising violations, there's 8. And again, this is those types of things where, they're putting an A-frame sign out in front of their business and saying, hey, we have happy hour right now. Come in between 1 and 2 and you get $50 off. Can't do that. So we do see those quite a bit, especially with the IV therapy NDs that are doing nothing but IV therapy. So we do see that quite a bit. Failure to update addresses with the committee, that is 0 now. So people are starting to do what they're supposed to, so that's always good. Substance abuse related violations has went up to 7, and that makes up 13%. We have seen a little bit of an uptick, especially in applicants, which usually they'll be told, hey, this was done, 5 years ago. If you have something else that is, egregious like this again, we will take action. So we do get those from time to time, and then we also have some that are against actual licensees that are already licensed. So there's that. Unfortunate that violation is going up. Unprofessional conduct, 34 cases of unprofessional conduct. Now I can tell you that there are times where we get several complaints for the same individual, or several cases that that have to do with more than one licensee. So sometimes that's why you may see that this has went up so significantly. Just for a little bit of information there. Records only, and this is either not releasing records or records that are being improperly maintained. That there's 1 there, and that's 2%. And then patient harm, there's 3 or 6%. So right now, unprofessional conduct does make up the majority of that subset of enforcement violations. Is there any questions, Dr. D'Amico?
So these are listed as violations, meaning they've been confirmed as having violated.
These are allegations of violations that have maybe been done or not. So they're in investigation right now. They have not been confirmed.
So we might want to just label these allegations in the future, just so it's very clear.
Sure.
Because sometimes what percentage of allegations do you think end up being true on average?
On average, depending on what type of case comes in, usually those unprofessional conduct ones, there's usually merit to them.
Mm-hmm. Okay.
substance abuse related, that could go either way. And sometimes depending on what substance is being used, it's hard to even, you know, determine whether that is, you know, been violated or not. So, you know, we'll see. Of course, these are again still in an investigation process. So it could come that, you know, some of these don't have merit to it. And then the ones that we find that have merit to it will eventually come to you guys in the
And
form
for
of
unprofessional
accusations.
conduct,
Mhm.
I think we ask you this every meeting because we forget, but I think that includes, um, you know, improper boundaries with patients,
Yes.
or that's all I can think of actually. Are there
Yeah.
other examples that might
There
go in
are.
there?
So overprescribing, not prescribing at all, prescribing in a way that you're not supposed to, like a vaccine, and you get your license revoked. So yeah, their unprofessional conduct can be it just kind of anything and everything that doesn't fall within those other kind of breakout violations. They would fall under the unprofessional conduct. Anything that an individual would do that would keep them from being licensed would go under unprofessional conduct.
Thank you.
Of course. Were there any other questions on these? All right, moving right along. We've already done the budget update, so I think that is, oh no, we still have more, sorry. All right, I got a little gung-ho there, but for board member training, okay, we do have it there. So the board members, of course, have required training that they have to do. The EEO policy is a policy, the SHP, which is the sexual harassment prevention training, is also another one. Board member orientation, which has to be done within a year of an appointment or reappointment. Defensive driving training, ethics, and then the information security are usually the ones that are required by board members. However, because our board does not have a DCA mail, actually, maybe you guys do have a DCA mail. I think we set one up for voting in enforcement cases in Breeze. So I think that you guys will actually have to do the enforcement security now that I'm thinking about it. I forgot that we set that up for you. So in any case, the EEO policy, the SHP training, and the information security policy has been sent out to all of our members except for member Yam. Once the training portal has been created for him, those courses will be sent out to him as well. So if you guys haven't received it already, you should have received an update on those trainings yesterday, giving everybody kind of what their specific requirements are right now. There are some people that are due for ethics again. There are a couple of people that need to get the defensive driving done. And of course, this is a odd year, so everybody is required to do the sexual harassment training again. So just go ahead and please make sure that you look at your emails and check and see what you are required to do. I also sent out all of the links to help you get onto those trainings and get them done as you have some time. Is there any other question about training requirements?
Thank you for sending all those out, Rebecca.
Of course. All right. Let's see, Federation. So right now, I was going to bring this to you, but we just don't have any further information on any updates from the FNMRA at this time since the last meeting. There is a new meeting for the FNMRA that was scheduled for November 2023. So I will be giving you guys an update after that meeting is concluded. All right, and can you advance, please? All right, so the North American Board of Naturopathic Examiners, NAMNE Advisory Council meeting update. I just wanted to let you guys know that I attended the NABNY Advisory Council meeting on April 21st, 2023 as the representative of FNMRA to provide insight as a state regulator. During the meeting, I provided information to the Advisory Council regarding California's AB 765 that would have prohibited NDs from utilizing long-use specialty titles such as naturopathic pediatrician and gastroenterologist. I also outlined the top 3 issues that NABNY should be focusing on in terms of 1 to 2 years from the perspective of regulators in supporting licensure efforts, monitoring industry standards and ensure NABNY is following and testing for those standards, and to continue monitoring types and counts of disciplinary actions against NDs nationwide. Additionally, I reported on data from the Federation of the Naturopathic Medicine Regulatory Authorities Disciplinary Action Summary, outlining the number of total enforcement actions taken on NDs since 2010 nationwide. And as you can see, naturopathic doctors still remain some of the safest practitioners. Since 2010 nationwide, NDs, violations that have been taken against NDs that have acted and have caused potential harm to patients indirectly were 15. NDs acts that harm patients directly were 154. There were also 60 administrative types of violations and discipline taken against naturopathic doctors nationwide. So there were a total of 279 disciplinary actions taken against naturopathic doctors since 2010 in all of the United States regulatory authorities for naturopathic medicine. Are there any questions about that? All right, great. I'm moving right along. Okay, so the consultation to the Idaho chapter of American Association of Naturopathic Physicians, AANP, and the Idaho Department of Professional Licensing, IDOPL update. Background for this, that the background of the naturopathic medicine in Idaho. First and foremost, Idaho has an existing board that licenses naturopathic doctors as NMDs, naturopathic medical doctors. The state of Idaho has just recently created through legislation another board that would license naturopathic doctors, or NDs. However, the NDs of the new board would not be the NDs that we're used to all across the United States. These NDs of the new board would be any healing arts practitioner licensed under another medical profession that chooses to become an ND. And basically what these individuals would do is they use their professional healing arts license and the licensing examination that is administered by their respective healing arts professions as proof of competency. They would not be required to take any additional education, training, or licensing examinations in naturopathic medicine. Further, after the ND is licensed, the individual could then let their original healing arts license lapse or cancel and would be able to remain practicing as a naturopathic doctor. In addition, the new board will start registering traditional lay naturopaths. The Idaho chapter of the American Association of Naturopathic Physicians requested that I provide testimony and consultation to the Idaho Department of Professional Licensing about the challenges that California had experienced with unlicensed activity and the cost to create and fund a new board. On May 31st, 2023, I attended a meeting and provided IDOPL with information on the challenges and costs associated with unlicensed practice. I also informed IDOPL that although there are laws in place that allow non-licensed naturopaths to practice naturopathy, that they may not diagnose or advise their clients to stop treatments prescribed by their licensed primary health practitioners. Further, lay naturopaths must provide the proper written disclaimers that is required by law for all unlicensed healing arts individuals, and that a lot of the time that the enforcement actions that involve the unlicensed participants here in California surround these types of violations. I also was able to provide the startup costs, and how funding was sourced for the creation of the former Bureau of Naturopathic Medicine. Do I have any questions about this?
This is Dr. D'Amico. I know that this qualifies a podiatrist to practice naturopathic medicine in Idaho. Does it also apply to veterinarians?
You know, I don't remember seeing the veterinarians on there as much as I want to say yes, because it's so silly that they're allowing any of this. I know that there was some dentistry, not all dentists, but there are some dentists that are allowed, that would be allowed to, podiatrist, allopathic, osteopathic, chiropractors, I believe.
Ophthalmologist, psychiatrist,
Yeah.
psychologist.
Yep. Yep.
Well, give us a
Yes.
moment to get our heads out of our hands before we move on to the next.
Is this actually moving forward?
It's already law. Right now, they're trying to create regulations and rules around the statute that was put in place. I can tell you that the board examination, or the licensing, not licensing, but the board examination that the lay naturopaths have produced and created to mimic what the naturopathic doctors have in place under NPLEX, has not been given or administered in since COVID. So that is one of the sources that they're trying to use in order to see if that, you know, they want to measure a competency. But as it stands right now, there is no way to make sure that the people that they are about to give an ND license to has any idea of what they're doing and being competent in naturopathic medicine. And that is a large concern to the rest of the naturopathic regulatory authorities, is that the consumers could very well be, you know, harmed in this, because you have people that are out there providing naturopathic medicine that have not been adequately trained and measured to make sure that they're competent in it.
That seems very, very concerning.
Yes.
I have another question. Also, is it your understanding, you know, the scope of a psychologist, of an ophthalmologist, of a podiatrist, of a dentist, the scopes of practice are different. Have they defined a scope of practice for the new ND title?
No, not yet. It is my understanding that that some of the discussions surrounding that, though, would keep let's say a podiatrist only providing naturopathic treatments for anything from the knee down. A dentist would only be able to do naturopathic dentistry if there is such thing. So these are the types of things that is in discussion, and that we would wholly hope for, if you know, this has to go on. We want to make sure that it is being done in a very safe manner, and it may have some concerns to us, because there is a federal law right now that would allow the spouses of military personnel to come into our state if they are licensed in another state and practice, as long as they've met the requirements. Now, we wouldn't license them per se, but they do have the ability to come here and practice under their license. So it is a little concerning, because there are other states that, you know, of course, have to follow the federal law on this. And if this, we can't just take any ND license now, because not all NDs are going to be the same. So again, this is the concern that we had. It was a concern that was pushed back, you know, when they were coming up with the legislation on this, but unfortunately the legislation did pass. I can tell you that on the board of this new ND board, it sits a couple of lay naturopaths, a chiropractor that wants to be an ND, and so they do have some people that are very that are looking forward to making sure that this is successful in Idaho. And I just have a feeling that the lay naturopaths, now that they're getting registered there, you know, they keep creeping towards this legitimacy, and trying to become licensed as naturopathic doctors. And as you know, they've made a go for your guys' title here quite a few times, saying that they should be allowed to use the ND title and that you guys should be using the NMD title. So we can see that this is kind of, you know, a way of them kind of creeping around and trying to establish themselves in states that did not have NDs for very long. So as you know, the NMDs that are there now have not been around for a very long time. But again, that this goes back to a case that was set precedents several years ago. I'm talking decades ago, where you know, a traditional naturopath that got his ND diploma, you know, challenged it and said, no, I should be able to use this title. I got this. I went to school for this, and this is what I do. And because of that, the case law in Idaho allows that ND title to be for people that are anything other than a naturopathic medical doctor.
It'll be interesting if people acquire this title as another professional and allow their original license to expire, if the scope, for example, the knee down or the mouth and neck, you know, for a dentist would continue with their ND license as a legacy scope, or if they would acquire a new scope, not holding the other license anymore.
Yeah, that's a good question. I don't know. I do hope that with all of the regulatory authorities across the nation, that they provide letters of recommendation on how to address this. Um, I know that there's several states right now that are, you know, side-eyeing Idaho, but it is what it is. It is law now. So now the only thing we can do is to make sure that we give any guidance that we have in some of the challenges that we've seen in the past here in California, and let them kind of, you know, sift through all of that stuff, and, you know, with the other states, suggestions and recommendations, and see if they can put something together that is going to allow this type of practice while still making sure that the consumers are safe. And, you know, that's basically what every regulatory authority's roles and responsibilities are. I You know, I don't think that this is the best setup, if you ask my opinion, but that's my opinion. So I'll leave it at that. But I can definitely see where this may have some big issues kind of going across the board. Are there any other questions on this before we continue on?
This is Dr. Singleton. I'm just curious if there are any other bills pending or recent passages of bills like this around the country that you're aware of?
That I am aware of, no. I know that on the East Coast, there are a couple of states right now that are trying to garner legislative support to create an actual naturopathic medicine doctors board in those states on the East Coast, which would be great because we don't have very many regulatory boards over on the East Coast right now. So getting them out there would be a good thing. And of course, they do look to California a lot for recommendations, because we're probably one of the boards that have been established for a while. However, we came after, you know, Washington, Oregon, Arizona. So, you know, those are always the states that they go to first, because they're so broad in their scope. They actually allow NDs to practice as they were trained. Unfortunately, here in California, we are severely restricted in allowing you guys to practice to your full training. And again, that's not something that the board has any ability to change. That would be something that the professional association would need to take up. But I know that we've had some discussions with them in the past because there are some things that do really restrict the licensees under our board that would be a benefit to the consumers if you guys were allowed to do. So, there's always some suggestion or recommendations that we provide when other states do come up to us and request that. And the unlicensed practice is the big thing that they always come to us for, because we have such a large challenge on that field there.
This is Dr. D'Amico. I just wanted to mention, maybe of interest to you. In the last year, I read the Naturopathic Medical Doctors Law in Idaho, and it actually allows them in law to have hospital admitting privileges in Idaho.
Yes, they do. Idaho is very receptive to natural treatments, and that is the reason that that they have created this board. And I can't remember the board name now. It's slipping my mind. It's something like the Board of Natural Medicine or something like that. But basically, they're all for functional medicine out there. Their people want it, the citizens want it, obviously, because this legislation created this board, and it is what it is. So, the actual naturopathic doctors, the naturopathic medical doctors in Idaho do have a very broad scope of practice, and, what I think should be across the board. I think they should all have hospital privileges. Again, my opinion. All right. Are there any other questions before we move on? All right, great. And that concludes my report to the board. Thank you.
Thank you so much, Rebecca. So agenda item 7 just has to do with the transition to postcard notices on renewal applications. So if
Yes, I thought I was done speaking, but apparently I'm not. All right, so
Madam President, Rebecca, just
Yes.
briefly, I want to make a record for the last two agenda items that there's no public present, so we don't need to take public comment. Might want to just check after each item, otherwise I'll be interrupting you and making that record. Sorry about that.
Absolutely. Thank you so much.
thank you.
All right, so moving along, during the November meeting, I reported that staff was working on transitioning from a 10-page renewal form to a renewal notice postcard. This will provide cost savings in postage expenses and will be a greener way of doing business. The postcard will provide instructions to the licensees on how they should go online to complete the renewal process and pay for their license. The design of the postcard was completed along with updating the new board name and location. You can see a sample of the front and the back on your screens now. During the last meeting, staff advised that due to limited resources, we would try to transition to the new postcard in February of 2023. However, due to the office move, we pushed back implementation. I'm happy to report that we were able to work with our Breeze team, and this is now scheduled to go live in our August 9th, 2023 Breeze production release. We are working with our web team now to add additional instructions that will assist our licensees in registering for an account on Breeze and linking it to their license records. Again, this is just to, help with the time of the processing for renewals. Of course, I'm not sure if any of you guys still send in your renewal in a paper format, but those take a minimum of 15 days to process, and 15 business days, if I didn't say that, to process. So doing an online renewal is usually renewed within a day. All right, any questions on this? All right, I'll give it back to the chair for public comment.
That looks great. Are there any members of the public present?
This is the moderator. No, there are no members of the public.
Wonderful. So then we already did agenda item 8. So we are now moving on. You're on again, Rebecca, to agenda item 9, which is the new program name, logo, discussion, and possible action.
Perfect, thank you so much. All right, so if I can have you advance to the next slide, please. All right, so as you guys all know, this here is the current logo. I had brought this to you guys back in November when we chose the logo and decided to stick with the traditional colors due to the time that we had to get this done before the first of the year. But we did promise that we would bring several options of color selections back to you guys if you wanted to revisit that. So that is what we're doing today. And as you see on your screen now, we have a couple of different options here. This is option B, C, and D. On the next page, you'll see, I'm sorry, on the next slide, you'll see options E through G. And then on the very last slide, you'll see option H. If you guys wanted to leave the current logo as is, you are more than welcome to do so. If you wanted to, have a discussion now and figure out if you want to change it, you may do that as well. I will go ahead and give this back to our chair.
Great. Is it possible to go back through those slides again? And then how would we determine if we wanted to change it?
So I think maybe the easiest way would to, take a vote to see if anybody wants to change it. And then if there are some people that may have want that color changed, then we can move forward on that.
Can we see the original again?
And the original is up in the corner of each of these slides, so you can
Oh,
kind
right.
of see it
There we
side
go.
to side with the others if you would like.
Mhm.
And some of these, like option C, is really similar to what we have now. They just kind of lightened the ginkgo leaf,
Mhm.
maybe a little bit more red tone in it.
This is Dr. D'Amico. We have a attachment A9 that has all the choices and letters next to them on one sheet.
That is correct.
And may I comment?
Please.
So I'm looking at all of them, and I just would like to share my thought process because I would like to discuss this. When I look at these, and I think Dr. Singleton has a good eye for this as well, I'm not really into the brown so much, or the brown reddish color. Our current logo, the ginkgo is a very muddy green color. I really like the brightness and the color of green in selection E. Because it's the most natural color green. I think the blue one, which is B, looks nice, but it's kind of reminiscent of Blue Cross Blue Shield. And I think H looks good, which has green with a gray leaf. But I think that this kind of green logo idea has been co-opted by the cannabis industry in California quite a bit. And I don't like, but I still like it better than the reds or the browns because I don't like any kind of feeling of muddiness in the logo. So just wanted to share my thoughts.
Great. I just have to say, this is Dara Thompson. I actually agree with everything you just said about the logos and their aesthetics. Looks completely on board with that.
Hi, this is
Davidson,
Bruce.
Dr. Davidson, yeah, thanks.
Hi. Yeah, so you ended up endorsing E, is that right? Did I get that right?
That's the one if I have to choose from this set, that's what I like the best.
Yeah, I would agree with that as well. I agree with the your comments about the color combination.
Do you have another comment, Dr. Davidson?
No, I was just fiddling with the button there.
Definitely. Does anyone else have a design they like more than E?
I agree with what Greta said. I do like option B a little bit more just because it's bright, but I don't like that blue.
Yeah, I would also say I like E, and then can we go to the next slide? Oh no, the other one. I also like G. It's a little sharper, but I don't strongly feel one way or another between those two, E and G.
Dr. D'Amico, neither do I. I think it's clearer on the shield, but it's less bright and more faded in the ginkgo. But given that the ginkgo's a shadow, maybe that's okay. At least the color green is somewhat in the realm of natural.
What it actually looks like on a ginkgo tree. Great. So I guess my question, given all of these options, is do we want to do some sort of a vote on these? Should we make a decision today? If we do a vote, I think we need to, choose one and then do a roll call vote and see if everyone's okay with it. So Rebecca, is this something we can decide today?
You can decide this today. And I had raised my hand, I wanted to give you guys some clarification. If there is a ginkgo color that you like on one of these logos and the shield and name on another one, you can definitely, vote that way as well. You can say, I want the ginkgo color from E placed on option G, and that's what we want. We can definitely make that happen.
I mean, at this point, that's what I would like, but I kind of want to see them together so that I
Sure. So if you would like, if what I'm hearing is you like the green from on the ginkgo from option E, but you prefer it in an option G where it's a little bit crisper in the shield and lettering, we can definitely reach out to Rick Wong and see if he can go ahead and switch that up for you, and I can bring it back to the next meeting if you would like to do that. I definitely don't want you to vote on something that you haven't been able to visually take a look at and make sure that it's still as, pleasing as we think it might be.
And can you have them go ahead and add E and G to that mock-up as well? In case we don't like it, we can revert back to one of the originals. Rebecca?
Okay.
Thanks.
Is anyone opposed to that option?
I think that sounds great. I was also noticing that our logo or our potential logo is not on the postcard. Is that something that we're planning to do?
No, because there's not enough room. We are really limited on those postcards. So if there is any logo, it would probably be the either DCA or state logo.
Okay, got it.
Great. So it looks like we have a plan to combine the ginkgo leaf from option E with the shield from option G and bring that back as well as the originals. And then we'll just have 3 things to vote on at the next meeting.
Perfect. I got that down here.
Fantastic. Are there any members of the public present?
Moderator, no members of the public are present.
Okay, agenda item 10 is discussion of prospective legislative proposals. Do we have any of those, Rebecca?
Okay, sorry about that. I was not unmuted. So this would be where if there are any proposals, legislative proposals that you guys would like to discuss and maybe start developing and finding an author for, like maybe, you know, adding recertification for IV therapy or and any of these items that, you know, we see little issues with that you guys are wanting to do a legislative proposal for, this would be the time to discuss those and make a list of them.
This is Dr. D'Amico. Per a previous agenda item, I would like to have assurance that a search has been done through current legislation for the words Naturopathic Medicine Committee to make sure that we've caught all the instances where it needs to be changed to a board, so we can bring a legislative proposal to change them as needed. I know they say they kind of do them as they come up, but I wonder if being proactive might not be better. I don't know what the potential impact of doing that or not doing that would be.
I'm writing as you're speaking. I'm sorry. Okay. And I do have already in a an additional agenda item for future meetings was the Business and Professions Code Section 3640.8, which had to do with the online courses that Greta had brought up a little while ago. So I do have that. And if that is something, Dr. D'Amico, that you are concerned about the way that it's written, or that you think that it needs some updating because of how tech has advanced, then that is something that would be brought up here as well.
Okay, yes. I was concerned when I saw that. I attended, as I think some of you did, the town hall about the merger between NUNM and Bastyr earlier this week. And they have an actual first year option off that's all online.
Yeah.
And they're in their second year of that. And I think and they actually have a virtual cadaver lab. I mean, we're going to see more and more of this technology. And I don't know that I have proposed language per se, but I think that we need to update that section to reflect current educational realities. As long as the practicum part of IV is still in person, obviously. I know that even in the IV certification classes, they allow you to take the first section or a certain number of hours through live webinar, which technically, according to this rule, law would not be allowed.
Right. I know that they're
so important.
Yeah, and I just wanted to, this is Rebecca. I think Michael has a question.
No, I was just going to just sort of provide a little direction in terms of this item. We can discuss potential legislative proposals to the extent of whether or not we think they should be on a future agenda. But because those specific proposals weren't agendized, we can't really get into a substantive discussion on the issues. We can say, yeah, I think this should be on the agenda, or I think we should do a legislative proposal for this reason, but then we can't get in and debate it. So I don't know that you'd cross that line, Dr. Thompson, but I just wanted to sort of give that thought for the continued discussion.
Thank you. I definitely would support discussing this further because I think it's really very, very timely, Dr. D'Amico.
Mm.
I also wanted to comment on what Rebecca had said, regarding some of the things about IV therapy, et cetera. I think that the wording on those regulations needs to be redone to such a significant extent that we don't know what or if a legislative proposal is necessary at this point. So I think that we would need to wait until that committee reconvenes and works on that before we would be able to add that back in.
I think you're discussing regulations, right?
So what Rebecca had brought up is that if we would want to, for example, change the CE, what, as an example, she had said, if we wanted to change the CE requirement issue, that would be legislative, something we'd have to do. We are not anywhere near knowing if that would be something we would even want to do, is what I'm saying.
Okay, yeah, but I was referring to something that's already in our law that says that these things can't be delivered by any means except in person.
Right. I was
Okay.
addressing a different issue. I wasn't referring.
Gotcha. Okay.
Yeah. Those were
Thank
two
you.
different things. Yeah.
Got it.
Are there any other prospective legislative proposals that people want to make sure that we put on future agendas?
Do we want to throw in the big guns and say the modernization of the scope of practice with the formulary?
Absolutely.
I'm so sorry, Mina. I just missed that. What was that again, please?
It's the scope modernization. So
And
including more in the
formulary,
formulary.
she said.
Perfect. I got that down. Thank you.
Mhm.
Yeah, that's an important one.
Rebecca, if we have other items we'd like to suggest for discussion for legislative proposals, we can send them to you after this meeting if we think of something later, correct?
Oh, absolutely. You guys can always send me something and we can definitely add it to the agenda for next board meeting.
Great, thanks.
Of course.
Anything else for this agenda item? Do we have any members of the public present?
Moderator, no members of the public present.
All right. So speaking of future meetings, let's not make it another 6 months. So let's discuss our future meeting dates.
Dr. Thompson, do you want to do that before we discuss future agenda items?
Oh, I am so sorry. I had thought were kind of incorporating that into the last one. Yes, let's definitely discuss future agenda items first and then future meeting dates.
I wanted to request that we take Christy up on her proposal to educate us about the rulemaking process at the next meeting, since we're going to hopefully have new board members. It'll be very helpful.
Yeah, that's a perfect time to do one. Okay.
Thanks.
All right, let me just go ahead and list what I have already. So there was supposed to be an executive officer evaluation. Unfortunately, it just time got away from me and I was not able to get that information out to you guys in advance. There was a little bit of time that's needed for that one. So I will forego my raise this time and go ahead and put it onto the next agenda item list, 3640.8 online course. Which was requested by Dr. D'Amico. I also have the IV therapy on here as well. We also have from the prior meeting that I have also been researching the authorization to have naturopathic doctors sign on DMV and EDD forms. There are a lot of different California codes that would need to be changed for this. So I am going to put this on here so that we can discuss it next time. Also, the rulemaking process that Christy had graciously said that she would provide to us is on here as well. So are there any other items that need to be placed on the agenda?
This is Dr. D'Amico. We discussed briefly, and I think this was for the subcommittees taking it up. If you think the subcommittee is actually going to meet, and that's a question, of using or considering the use of the elective NPLEX exam for IVs being adopted as a regulation in our state.
I believe when you said, you sort of breezed over this a little bit, Rebecca, but you said the IV item is on there. Is that a report from the subcommittee after we reconvene and consider all of those issues?
Correct, yes.
Okay, so yeah, I do think that that is part of the discussion. But we'll just need to make sure that that subcommittee meets before the next meeting because it's clearly need to bring some new information.
Right.
Okay. And then I think Christy might have said that she would be able to meet with the subcommittee as well.
I'm not sure if she said that, but I will definitely see if we can get her at least onto one of them so that she can help kind of give you guys some guidance on maybe the best strategy to take when starting to kind of relook at these proposed language.
Great.
So I will reach out to her for that.
Any other items? And remember, you can send items to Rebecca in between now and when the agenda is posted, and they can be added prior to that time. For meeting dates, it does sound like we should try and get something in place for early fall. It is late June now, so we always have this issue with fall where we're trying to work around a bunch of different issues as far as like vacations for people who have kids, holidays, things like that. But I think it would be great to get something on the books in September if we can find it. What do you think about that, Rebecca?
So if that would be great. I did get some recommendations and how other boards do it, and now that we're a board, we might want to start following suit. But in order to make sure that we have our legal that's going to be able to be present and all of the respective other presenters that I usually have on here, it would be great if we could do like a year in advance. I can get doodles out for the quarters and just give, several dates, and then everybody can kind of give back what they have available for those, and we will just start kind of scheduling a year out so that we are guaranteed to have a meeting room and all that kind of stuff. I can tell you that there is a change, and that's why I really wanted to make sure that this board meeting happened today, because after today, the virtual meetings will be changed a little bit in that any board member that is coming on virtually would still have to put out their location. So we just want to make sure that we have adequate time to set these meetings up in advance.
And this is Dr. D'Amico. I don't know if I'll be at the next board meeting. My term is, I'm in my grace period, but I really, really, really encourage us to have a meeting in person. And I think next time would be a great time, unless you're expecting somebody to be, appointed within a week of that. Because so many people haven't seen each other in person since 2019, and it's just better for the board if we have some FaceTime and know each other. So I encourage you, if you can get here or you live anywhere near here, to come in person. That would be my encouragement and request, even if I'm not there.
That's a great request. I
Yeah,
miss you guys all in person.
I know, we need snacks and things.
Yeah.
So as far as scheduling out, are we thinking of scheduling quarterly meetings? So
Yes.
that there'll be 4 meetings per year. I love the idea of scheduling them in advance so that they're set. And it does seem like if we're going to do that far out, that we do need to do it via Doodle.
Yeah. So what I'll do is I will come up. Thursdays are still a good day. Is there any day that is not a good day for doctors? I'm guessing probably Mondays is not a good day. So I just want to make sure that I don't add dates on there that everybody's just not going to answer for. So I will definitely keep Thursdays as one of the go-to days on those doodle requests.
We could probably find out what's the worst day for everyone, and I'll say mine is Wednesday.
Okay.
And I think Dr. Yoon's is maybe Tuesday. Is that right?
Tuesday and Wednesday. Yeah,
Tuesday and Wednesday.
Thursdays work great for me.
I will also put in a vote for Thursdays. It's Dr.
Okay.
Thompson. You know, I mean, given enough notice, I can make any day work, but yeah, Thursdays are far and away the best.
All right. What about Fridays? Are Fridays a bad day for you guys?
It's a good day for me.
Okay. All right. Well, in that case, I will get some doodles out, and I'll just send them out, respectively for the quarter that we'll be voting on. So I will include both Thursdays and Fridays. If there are, if we don't get enough responses back in a day that's going to be good for everybody, then I may add a Monday in there or something, which is a bad day for us, but we can always make it work. So we'll go ahead and get those out again quarterly. So we will try to shoot for a September meeting for this third quarter for 2023. The fourth quarter for 2023, I would say somewhere between November and December, since we're going to do one in September. And then we will go ahead and start next year's doodles as well. So I'll get all those out to you guys within the next day or two so that we can start scheduling those and get them put onto a calendar. And I think Dr. Davidson has a question.
Hi, thank you. Yes, for September, I'm happy to join a meeting, but I will be traveling the last 2 weeks of the month. So if it's the first 2 weeks, if there are options in the first 2 weeks, that would be preferable for me.
Okay.
Thank you.
All right. Of course.
This is Dr. D'Amico. While we're at it, I will be out of the country between September 6th and 19th.
So the first week of September then is what I'm hearing.
Well, I'll be gone the first Thursday. So if we do it the 1st or the 4th is Labor Day. So that leaves Friday the 1st or Tuesday the 5th, unless we go to the 3rd or 4th week.
Okay.
If you want me to be there.
Okay, sure. Let me go ahead. What I'll do is I'll just go ahead and send out the doodle polls, and we'll just see which day we have the majority of people that can join. And as long as we have quorum, then we'll stick with that day. And then if we, of course, have any issues, then we'll have to just do a new doodle poll. But we'll get it done. We always do.
Could you please convey to Christy how much we appreciated her being here today? I think everything was so helpful.
I absolutely will, and I wish that Christy would have looked at this stuff a lot sooner. It would have saved us a whole lot of work. But I am glad that she's here now and kind of guiding everywhere where we need to go. So I will definitely convey that message to her.
And I really want to
I
thank
say
Michael.
thank her all the time too.
I really want to thank Michael Kaunitz as well for his comments and being here and attentiveness. Thank you.
Of course, I'm always happy to serve the board, and makes for a more interesting meeting when I get to participate a little more. So did we, I do recall that we skipped item 3 for the minutes. Are we going to go back to that one?
Yes, we do have the minutes now. They are up online.
Oh, so we're able to go back to that today. I thought we were pushing that to a future meeting.
We would have only had to push it back if it was not available to the public, but it is available now before we get off the meeting. So if you guys are ready and you would like to go ahead and approve the minutes either as submitted or with amendments, we can do that. It would only take a couple minutes.
And Madam President, that's your call. It can be done either way. We can do it at the next meeting, sir.
Has everyone had a chance to review those minutes? Are they ready to approve them, I guess is my question.
Were they revised since you sent them to us, Rebecca?
That is correct.
I might suggest we take the time to look over if they were substantive changes. Maybe it was just clarification and grammar. I'm not sure.
Yeah, I think there's no substantive changes. That they were just grammar changes on there.
Okay.
Couple of periods and stuff. So
Does anyone feel like they are not able to approve the meeting minutes at this time? Great. Do I have a motion to approve the meeting minutes?
I'll move, this is Bruce Davidson. I'll move to approve the meeting minutes of the November 10th, 2022 meeting.
This is Dr. Yoon. I'll go ahead and second it.
Wonderful. Do we have any members of the public?
Moderator, no members of the public present.
Great. Rebecca, can you do a roll call?
absolutely, my pleasure. Dr. Dara Thompson,
Aye.
Dr. Greta D'Amico,
Aye.
Dr. Vera Singleton,
Aye.
Dr. Bruce Davidson,
Aye.
and Dr. Mina Yoon.
Aye.
Great, and that moves with 5 ayes. Thank you so much.
Excellent. At this point, I think we've gone through all of our agenda items. Does anyone have anything else they need to say before we adjourn for the day? Well, I want to thank everyone for taking the time to be here and going through everything in so much detail. I'm looking so forward to seeing everyone in September, and I hope you have a great rest of your day. I am now adjourning the June 29th, 2023 meeting of the California Board of Naturopathic Medicine.
There you go.
There we go. It is 1:52 p.m. Wait, no, 1:32 p.m. Thank you.
Great. Thank you, everybody.
Thank you. Bye-bye.
You.
Thanks.